show support for Lindsay.
And for Kevin Reddington, who's amazing. He's done just a superb job.
Yes, thank you all for being here.
Team Lindsay.
Team Lindsay.
Lindsay.
All right, just creep up front so that everyone can see them.
Would you like to say anything for Lindsay?
Team Lindsay. You're not alone. We're with you.
Team Lindsay.
Say anything?
Lindsay.
We're here to support Lindsay and also all the women in America who's gone through our healthcare system and has been diminished and let down.
The healthcare system failed her. Hey, I work in the healthcare system. I'm saying that out as it is and how I see it. They failed her.
Or TV, you guys want to talk?
Hi.
To help women that are in need after giving child and just our own health care regarding it. So it's important to be here.
Oh, yeah, that's And what made you, how did you get involved in this case? Walk me through the beginning of this.
I was devastated the night that Lindsay had been for in shambles for autopsies, and I could not sleep. So at 1 o'clock in the morning, I decided to do something, and all of these wonderful people decided.
Hey, you want to say something? We don't have too many men saying anything.
Oh, I love this.
I'm here supporting my wife, Renee Kimball. She's the one that put this all together. I'm the man that holds everything.
All right. Anything else you want to say?
I'm here to support Mrs. Clancy, too, and hopefully she gets the help she needs and the justice.
Thank you.
Hi. I'm from Acushnet, Mass. My name is Amy. I'm also a mental health worker for 15 years, and I'm here to support Lindsay, her children, and I hope she gets the help she needs. Massachusetts failed her, and we need to stand and show people that mental illness is a serious thing, and more women need support.
Thank you.
Go Bills. Sorry. I'm so sorry. Between 8:15
I got a picture.
My husband will help Renee. It could be, yeah.
I've been following this case. I was involved in the Karen Reed case, the Sandra Birchwell case, the Just on Root case. And right now we're trying to get the Norfolk DA election is coming up with Adam Deitch. And I've been standing out. Oh, no. Yeah.
So you did pool the other night? Yeah. Nobody from the group wanted to do it. Liz was here, and he's like, "Oh, I got to leave at 1." Oh, okay. I was wondering, because he usually was in the Chinese flag. I don't know that they. So what is like? Hey, how you doing? Oh, I know.
and pull off a shot of.
stood in line for jury duty here. Oh, good. Yeah. You would think that gosh, was in there. Oh,
I mean, I put actual metal facts on there, okay? And I listed my references. Very small one. I feel like I need to say that. Oh, really? Oh, what's it?
As much as they can.
I know. Me too. Girl, what?
She said I am disgusting, and then she
It's always the one that does the most, doing the most reviews, like putting in all the, yeah. That's my choice. Yeah. No, he left. He left for me to clean up all the mess,
No.
You missed out a little bit first because you see everybody at the desk. And you were good. You were good. I did too late. Oh, that's okay.
Emotion's good. No trick questions. You can just say what you want to say. I won't even ask you any questions. You can just tell me why you're here.
I know.
If you want to tell us your name, though, hang on 1 second.
So my postpartum, I would say I had, busy. I'll be a manager.
Go ahead. Tell me your name and you want to hold it?
No, it's fine.
Oh, go ahead.
My name is Jamila, and I'm here to bring the awareness for women mental health. Not just women mental health, but mental health in general.
Okay. You want to tell us what you think happened as far as the case is going?
I don't want to say what happened, but I can say that she was looking for help and she didn't get the help that she needed. She got downplayed. And this is what happened when women share, I don't feel good. Because we have to be strong 24/7. We cannot feel weak. We cannot feel I cannot deal with this right now, because we have to, as a woman, as a mom, we always have to be there, regardless. Nobody will be there. Oh, let me take that out of your back. So I don't want to say what happened. I know that she needed help.
What do you think is going to happen?
I hope she get the help that she needs, and that the world get educated and informed about mental health and a woman mental health, because that's real.
Do you mind telling me your first and last name and spell it for me?
Jamila Rosa, DJAMILA ROSA.
Great. Is there anything else you want to say?
The system needs to change.
That's perfect.
Thank you.
Listen, if you let this girl talk, she's like,
I'll talk to anyone.
Oh, there we go.
Literal dream.
Anyone and everyone.
Well, you want to start off with just telling us your name and spell it?
My name is Jessica Giannetti, Jessica Giannitti.
You want to tell us why you're here today?
Yes, I'm just here my sister and I are here to support Lindsay. It is not a protest, not a rally, just a silent support to let her know that she's seen, she's heard, which she was not seen or heard by the medical system, by her doctors, by her husband. So we want to let her know that she is seen and heard now. And we're hoping that maybe this unfortunate circumstance will maybe shed some light on postpartum for women, because unfortunately that is overlooked a lot, and women do get dismissed quite a bit from that.
You want to walk and talk? We'll go to the end over here. I think we're about to get an interesting shot. They're all heading to the end. Here.
Oh, okay. Let's go. We're going to walk and talk.
Yeah.
We are going to see Lindsay, I think. I'm not positive. I think that's what we're doing, though. So here we are with everybody. We have to listen to the police first. We've got rules. Okay. We're listening to the rules.
Intimidation, which is a criminal offense, and we will have to take you into custody for that, and we don't want to have to do that. We want to support you guys in everything you're doing out here, but you guys kind of have to help us with that as well, okay? So if we can all do this the right way, it'd be greatly
No yelling at anybody, no swearing, no being aggressive.
Great.
Thank you.
Here, we want to pick up your face this way. You want to tell us how you feel about the justice system and how everything's been going for Lindsay?
I understand that the jurors do have a job to do, but I do think that there is different ways to go about it. I do not think that they are being tactful in the way they're going about it. They're being rather aggressive, and I just don't see this being done appropriately. I really don't. I don't think that it is at all.
If you could say anything to Lindsay, what would it be?
Lindsay, we see you. We hear you. We wish that you were not failed, hon, and you were. And at the end of the day, I know nothing is going to bring those children back. Nothing. But hopefully this, again, will shed some light on postpartum, and maybe the next woman won't have to suffer. And I just hope that you, at some point, find peace. That's all I really can hope for you. And you, again, you're seen and you're heard. And we hope that you find peace someday.
Great. Is there anything else you want to say?
No, I just that we're here to support. And again, thank you for everybody for being here.
Thank you very much.
I answer right back. I'm like, my life is happening.
Great, but then there's the people that will, abuse it and look at it as, and that's those the ones I'm like, oh god, this is so.
Like I've seen people at 5:45. Yeah, because I said if you can't make it here.
Cabin stuff.
It's very moving for them. They don't forget it.
Mr. Reddington, what's your message to all these folks who are here today?
Thank you. That's all I can say. It's amazing.
We love you, Kevin.
Kevin, are you surprised at just how much attention this case has gotten? I mean, people are coming from Maine.
It's the message. It really is. It's the message that just has reverberated, throughout the whole country.
What is that
Reddington's
message?
fighting for women's rights.
No, I
for
don't.
healthcare.
I think that it's the mental health system. I hate to use the word health care because, unfortunately, in this case, we can see it hasn't been health care, and I think that it shines a light on this issue. I mean, when a woman is going through what so many people do, and they go to a doctor, and the doctor says, here, take this pill, take that pill, take this pill, and then they basically treat them for 15, 20 minutes and send them on their way. It's just not right.
And to those who can't wrap their heads around sympathizing with a mother who killed her 3 children, what do you say to them?
I think it's almost like when you're picking a jury, and sometimes somebody will say, well, I don't agree with, this allegation of murder. I mean, none of us do. But that's what we have juries for. They pass between the government and a defendant to see if they can prove their case.
Is she aware of this support, and what does she think of this support?
I'm going to go in and see her right now. I'm sure that she is, and if she isn't, she will be.
What do you think about?
She's so beat up and just so sad. But this will really help her out, I think. It's awesome.
Tell her we love her. What do you think about you being the advocate for all women right now?
I'm not an advocate.
You are. But you are. But you are.
Get to work.
But you are.
Busy day.
Thank you, guys. Thank you. Is she already inside the court? Is she already inside the court?
Hey guys, that was that's live in the action. That's what's happening
I did. I was like, I got all the wedding stuff done yesterday.
Probably, because he's got 2 points yet. It looked like it's
Did you notice that they rolled down the window for her?
No.
Yeah, so they're the two jurors.
Did she say that that's what she said?
I'm so sorry. I didn't mean to jump in your shot.
I'm here for everybody to get in front of my camera, so don't worry about it.
Do you mind if I step through?
No?
Okay.
You get me through? Yeah, I need you. Yeah, if you can, let's go. Wait.
We're all set up here.
going to be in a short recess, and we're going to bring the jury back in, and we'll call the next witness. Okay?
Court, all rise.
Court is back in session. Please be seated.
All right. Counsel, we ready for the jury?
Yes, Your Honor.
All right. Bring them in.
All rise, please. Hey, 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 all persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth, within the Honorable. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, court is now in session. Please be seated.
Yes.
Before the court today, we have a continuation of the jury trial matter Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right. Thank you, Madam Clerk. Good morning, everyone. Nice to see you again. I know I just spoke to you probably about 10 minutes ago. But again, I want to ask you those questions, then we'll talk a little bit about what our schedule is today and for the rest of the week. All right, so first question, has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be fair and impartial as a juror? Next, is there any other serious matter or concern bearing on your service as a juror that anybody needs to bring to my attention at this time? Again, thank you for following those instructions. And then in regards to our schedule today, you're allowed to kind of roll your eyes because I'm going to say we're going to have kind of a short day today. All right? And that is, as I talked to you yesterday about an issue that has nothing to do with any of the attorneys in this case. All right? It's just something we're going to work out, and I anticipate it will be worked out so that tomorrow you should count on a lengthier day. All right? I've talked to counsel earlier this morning in regards to where we are in regards to the schedule and the timeline. We are still, if not on schedule, still ahead of schedule. All right? And this delay that we may have a little bit this afternoon won't affect that. All right? So I just kind of wanted to let you know that I appreciate it. I know you came in here this morning. It's going to be a short day, but also gear up for a longer day tomorrow. Okay? And so with that, the other thing is, I told you it's got nothing to do with any of the attorneys, but it's also or the parties. So you're not to speculate about what this might be. It's also you're not to hold it against either of the parties in regards to this. All right? If you're going to hold it against anybody, you can hold it against me. All right? So with that, we're going to return now to the evidence in this case. And Attorney Reddington?
Thank you. Sheila Kavanaugh, please. Let's see. Good morning. Just face Madam Clerk, raise your right hand, please.
Before the testimony of the other issues shall get to the court. Jerry, the matter now coming between the Commonwealth and the defense with the whole truth and nothing but the truth. Yes. Thank you. You may have a seat.
Just watch your step right there.
All right, well, good morning.
Good morning, Your Honor.
All right, I just ask you to speak into that microphone and keep your voice up so the jury can hear you. Attorney Reddington.
Thank you. Good morning. Can you tell us your name and spell your last name, please?
My name is Sheila Kavanaugh, Cavanaughh.
And what town do you live in?
I live in the town of Belmont, Massachusetts.
And what are you doing for work now?
I am a board-certified chaplain at Brigham and Women's Hospital in Boston.
And I didn't know that there were board-certified chaplains. What does that mean?
Well, to become board-certified, you need minimally a master's degree in theology or divinity. You need to complete 1,600 hours of training post your master's degree. 1,200 of those hours are occur in a clinical setting, and 400 of those hours are in a classroom setting where we study various disciplines: psychology, sociology, philosophy, theology, and ethics. Beyond that training, we need to acquire 2,000 hours of additional clinical training before we can even apply for board certification. And we have to demonstrate mastery of 30 competencies before we go to a national board, and they make the assessment. I also need an ecclesiastical endorsement, and in my case, that was from the Archdiocese of Boston, from Cardinal Sean O'Malley.
And before you obtained the board certification in your education to allow you to be a chaplain, what did you do for work?
Prior to becoming a chaplain, which is a second career for me, I was a senior vice president at Fidelity Investments in Boston.
And how long were you senior VP at Fidelity?
16 years.
And are you married?
I am.
You have a family?
I do. My husband and I are the parents of 4 adopted children. When I was pursuing my master's degree at Boston College, it was a 3-year master's, but it took me 5 years because we adopted our 4th child while I was in graduate school. She was a 14-year-old girl from Bogota, Colombia.
And how long have you been working now as a chaplain at Brigham and Women's Hospital?
7 years.
In the course of your duties as a chaplain at Brigham and Women's Hospital, did circumstances bring you in contact with Lindsay Clancy?
Yes, they did.
Can you tell the jurors what happened?
I arrived on the morning of Wednesday, January 25th, 2023. I arrived at approximately 8:30 that morning because I was there to relieve the overnight chaplain who was carrying the pager. I was taking over the pager shift, which went from 9 to 1 p.m., although I was working a full day. When I arrived that morning, she said to me, "Did you hear the news?" And
so
sustain.
Okay.
So you got to object, so you can't say what someone told you, okay? That's called hearsay?
Okay.
Okay. So I can say, as a result of the conversation with that person, what happened?
I was summoned to the Director of Spiritual Care's office.
Did you have a conversation with her?
I did.
All right. And as a result of that conversation, what did you do?
I went to Unit 8C in the Tower Building of Brigham to meet with Lindsay Clancy.
And what time of day was this?
Roughly between 8:30 and 9:30 that morning.
And when you went in to see Lindsay, what did you observe?
Well, the unit itself was filled with law enforcement officers, both outside the doors of the unit. There was Brigham security, but the unit itself was flooded. There were people from Plymouth County, Boston City Police, Brigham Security, so I had to make my way through concentric circles of law enforcement to even get to the room. I was permitted to see Lindsay, although she could not speak at that time.
And what was her condition that you observed?
She was dressed in medical armor. She had tubes. She was intubated. She had bandages. She had a neck brace. She was just covered and layered in equipment that enabled her to breathe.
Now, I'm showing you Exhibit 121 and asking, this may be South Shore, or it could be Brigham and Women's, but is this indicative of what she appeared to be when you first saw her?
That looks like it's from South Shore because when, yes.
Did she have the same?
Similar.
Very similar?
Very similar.
Like that?
Yes, very similar.
Did you see her again on another date?
I did. I saw her the next day. Again, she could not speak. She was intubated as well. That was the first week that she was hospitalized.
When was the next time that you saw her?
The next time I saw her was the following week. I have a calendar here of my visits. I saw her on Tuesday, January 31st, and she had been extubated at that point so she could speak.
So the tube had been removed, she was able to communicate, and that was on January 31st?
I believe she was extubated the weekend of the 28th, but I didn't work that weekend, so I saw her on Tuesday the 31st.
All right. Tell the jurors what you observed and what, if any, conversation you had with Lindsay on the 31st. And let me ask you, how long had it been that they removed the tube?
Perhaps a day or two.
A day or two, okay. Tell the jurors what she said to you.
She continued to look like the photograph you just saw. She was covered, tubes everywhere, the neck brace. Her emotional state was very neutral, a flat affect. But I remember vividly the first thing she said to me. Now, she had heard me for a couple of days. We had been praying together. And so when I went in on Tuesday the 31st, she said to me as I held her hand to comfort her, "I am so glad my children are safe."
Was there any other conversation that you had with her?
I replied theologically to Lindsay, and I said, "Lindsay, your children are safe. They're safe in heaven with God." And I held her hand throughout that conversation, and we prayed for them.
Did she make any other statements to you?
She did. She alluded to having heard a voice, and the voice, according to Lindsay, told her that if she did not follow the command, neither she nor her children would be safe.
And did she indicate whether it was a male voice, a female voice, loud, soft?
She alluded to the fact that it was a male voice and it was persistent.
Any further conversation that you recall about that, not about general things,
That came up several times. I visited Lindsay minimally 14 times while she was hospitalized at the Brigham, and the voice conversation came up several times during several of our visits.
Now, after Lindsay was transferred or cleared to go from Brigham and Women's Hospital, did she go to another facility?
She did. She went to Spalding Rehabilitation Hospital.
And do you know when that was?
That was roughly late February, perhaps around the 23rd.
And did you continue to see Lindsay at Spalding Rehab?
I did.
Do you know when she left Spalding Rehab?
In the late March, early April time frame, perhaps.
Okay. Now, Brigham and Women's Hospital and Spalding Rehab are under the same umbrella of hospitals, is that right?
They are. So Brigham and Women's Hospital and Spalding Rehab are under the Mass General Brigham complex. So for me to visit Lindsay in Spalding, I was still within the same hospital complex, and her psychiatrist at Spalding, as well as the chaplains, advised me to continue.
You can't say what anybody told me.
Oh,
So, when she was discharged from Spalding Rehab, where did she go?
She went to Tewksbury State Hospital.
And fair to say that that would be back around February. Well, it's been a little more than 3 years, or 3.5 years.
Yes.
Is that correct? Now, when you saw her in Spalding Rehab and in Brigham and Women's, you were acting in the course of your job. Is that right?
That's correct.
So you're being compensated, you're getting your paycheck and that type of thing, right?
Yes.
How many times have you seen Lindsay at Tewksbury Hospital?
Perhaps 200 times.
Tell the jury why you continue to see her for 200.
Sustained.
So, can you tell us how often on a weekly basis you would see her at Tewksbury?
Yes. When Lindsay was admitted to Tewksbury State Hospital, I continued to see her on a weekly basis. We had built up a very comfortable, respectful rapport, and I felt it was in her best interest to continue that as she healed. She was still in deep grief. She was suffering.
Sustained.
So
that opinion would be stricken.
So, did she express anything about her children and their loss over that period of 200 times that you saw her thereabouts in Tewksbury?
Objection.
No, overruled.
Yes.
Other jurors?
Lindsay talks frequently about her children. She loves them deeply. She carries immense grief.
Objection.
Overruled. Next question.
And has that continued to your observation?
It continues presently.
When was the last time that you saw Lindsay in Tewksbury?
Just prior to the trial starting.
Thank you very much. Appreciate it.
Thank you.
All right, Kamala.
Thank you. Excuse me. Good morning.
Good morning.
You were talking about on January 25th, 2023, when you first saw Lindsay in direct examination, and you said that there were a lot of police officers in the area, correct?
Correct.
But you mentioned that some of them were security personnel from the hospital, correct?
Correct.
And you're aware that the security personnel for the hospital don't work for the state police, the Duxbury Police, or the Plymouth County DA's office, correct?
Correct.
So they're separate and apart from law enforcement, correct?
Yes.
And then are you also aware that on January 25th, 2023, there was a search warrant being executed to collect evidence from the defendant and from the belongings that she had at the hospital?
No, I was not aware of that.
Were you aware that that collection of the search warrant required state police and personnel from the crime lab to be present for the collection of evidence?
I was not aware of that.
Were you aware that following that, at any given time, there were only 2 officers, either Duxbury Police, State Police, or Plymouth County Sheriffs, at her room, the defendant's room, at any given time?
I do recall that.
And they were stationed outside of her room, correct, in the hallway?
Yes.
So that the only time you saw this large amount of officers present was on the 25th, when there were security from the hospital and search warrants being executed, correct?
Perhaps.
Okay. Now, you mentioned that on January 31st, 2023, you spoke to the defendant, and she told you that she heard a voice telling her that if she did not follow the command, neither she nor her children would be safe, correct?
Correct.
You wrote very detailed notes that are contained in the Brigham and Women's Hospital records regarding your interactions with Lindsay Clancy, didn't you?
Yes, I did.
And in all of these notes that detail every time you interacted with her, you never once wrote that she told you she heard a voice or what that voice said, correct?
Correct.
And you also said that this voice, talking about the voice, came up in several of your meetings, correct?
Correct.
And you never once wrote about any of it in any of your very detailed notes, correct?
Well, chaplain notes are not verbatim transcripts of patient conversations. I'm not there to evaluate the patient. I'm there to bear witness to their suffering.
Okay, but the question was, you did not document those statements in your notes, correct?
Correct.
But you did document some other statements in those notes, correct?
Perhaps.
For example, on February 6th, 2023, in a note that you wrote regarding your interaction with the defendant, you said that, or you wrote, Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again, end quote. She continued to express her fears of how her inability to walk may make her vulnerable to others in the future. Do you recall writing that?
Yes.
Do you recall writing on February 9th, 2023, that the defendant was sitting in a chair adjacent to her bed and appeared to be visibly engaged, energized, and hopeful than in previous visits? Do you recall that?
Yes.
You also wrote in that note, Lindsay spoke hopefully of being discharged when the time arrives to Spalding, correct?
Correct.
And then in February 13th, 2023, you wrote in your note that Lindsay also expressed hopefulness in relation to her physical progress. She feels she has gained considerable physical strength and agility despite an inability to move her legs. She admitted that she feels, quote, deserving of this, end quote, in light of recent events. Do you remember writing that?
Yes.
Do you remember on February 16th, 2023, that you wrote in a note that the defendant expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted that she would be cared for in a facility with an excellent reputation?
Yes.
Do you recall writing on February 16th, 2023, that Paula, the defendant's mother, and Lindsay, the defendant, were playing a card game as they communed quietly, and that Lindsay expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted?
Yes.
And again, you've got all these details about her feelings and her thoughts and what she's doing, but nothing about the voices that you spoke of so many times, correct?
Correct.
And speaking of Spalding, you continued to visit her at Spalding, correct?
Yes.
In those conversations with her at Spalding, did she tell you that how in those first weeks at Spalding, that part of her physical therapy, she was working out with a yellow exercise band? No?
I don't recall her telling me that.
Did she tell you that during that time at Spalding, she reached out to a social worker there and asked for help filling out SSDI paperwork to get an income?
That would be beyond the scope of our conversation.
She didn't tell you those things?
No.
Thank you.
So, counsel has asked you about her filling out a form for SSDI. Were you aware of what expenses her family were incurring as a result of her physical incapacity, paralysis, and being in the hospital?
From my experience with thousands of patients, I had a very clear idea of the enormous expense.
There's a difference between, as the district attorney very appropriately referred to, that your comments were about her thoughts and her appearance and her feelings. Is that correct?
Correct.
There's a difference, however, between privileged communications with a chaplain and observations of a person's feelings and thoughts, correct?
Correct.
Tell the jury what effect privileged communication has when someone talks to you personally as a chaplain.
Because I'm not a medically trained clinician, I approach patients in a vortex of trust. Some of our chaplains at the Brigham are ordained clergy. And so there's this understanding that when a patient interacts with a chaplain, the conversations are confidential.
Do you put them in medical records?
No.
The words, like Lindsay indicated that she felt uplifted, I think the counsel read that twice. Were those your notes, or is that what she said to you? Did she say, I feel uplifted, or is that your
That was my
observation?
perception of Lindsay. It was not her words.
Thank you.
Thank you.
Como?
You said you're not allowed to put the defendant's words in your medical records, is that correct?
No, that's not correct. It's not that I'm not allowed. It's an understanding, and it's a conversation that's held in confidence with the patient.
Then why are there direct quotes in these medical records from the defendant?
Well, they're not verbatim transcripts.
No, not a transcript of the whole conversation, but you put phrases in quotes. For example, on February 6, 2023, where it says Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again. So those were her words in your note, in quotes, in the medical record, correct?
Yes,
Thank
yes,
you.
I use my best judgment.
Okay. I would move to have these submitted as the next exhibit, the notes of the witness in her interactions with Ms. Clancy at the Brigham and Women's.
Any objection? No. All right. They may be admitted.
I have no further questions. Sorry.
Hey, Mr. Reddington, go ahead.
I have no further questions. Thank you.
Okay, thank you.
All right, thank you. May step down. All right, Counsel, can I see you? All right. I told you it was going to be a short day for you, right? And I appreciate your patience with us. So I'm going to excuse you till tomorrow at 9, all right? Same instructions. And that includes reading anything, talking about this case, watching anything. Just don't do it, all right? And when you leave here today, just drive, go home, wherever you're going to go, and plan on being back here tomorrow morning at 9 o'clock. The plan would be that it will be it will be a longer day than today. I appreciate you coming in here today. We moved the case a little bit today, and I appreciate that. So we were able to do that. So I hope everybody has a nice afternoon and evening, and we'll see you tomorrow morning for a longer day. And just remember those instructions from the moment you leave to the moment you come here tomorrow. Okay? Again, thank you so much.
All rise, please. Your next meeting.
Jurors, I'd like to the court will close the session. Please be seated.
All right. So what we'll do is we'll take a short break at this point. We'll come back. We'll do kind of a preliminary charge conference. We're going to just, which I know counsel knows, but for everybody else, discuss possible jury instructions, suggestions from counsel. Then we can talk about any logistical issues that we have for tomorrow, and then we'll probably recess at that point. All right, so this will be a short recess, and we'll come back up. Thank you.
Court, all rise. court is back in session. You may be seated.
Your Honor, for the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are clear, excluding the 18 jurors.
All right. All right, counsel, what I kind of wanted to do is at least have a preliminary discussion regarding instructions. And what I would generally do is after we have the discussion is then kind of distribute a draft to council so we could have a more focused charge conference the next day or so. But I just kind of wanted to get everybody's thoughts or kind of suggestions that they would be seeking the court to instruct the jury on. So kind of what I'll be using will be the model jury instructions, generally the model jury instructions from the March 2026, the latest suggestions from the SJC. And so Commonwealth, let me kind of hear what your thoughts are, and then I'll hear from the defendant.
So for individual instructions, we have listed opinion testimony, prior inconsistent and prior consistent statements, redactions. I don't think there are too many, but there were some on the death certificates. Stipulations and consciousness of guilt instruction. In terms of what we're looking for for the charges, we'd be looking for an instruction on first and second, with the theories of first being both deliberate premeditation and extreme atrocity and cruelty. In terms of the criminal responsibility instruction, we're asking that the instruction regarding intoxication not be given, because from our perspective, there's been no evidence of intoxication by drugs and or alcohol during the killings. There's testimony, and I think there'll be more testimony about the defendant taking pills after killing the children, and before killing the children, she was on low-dose prescription, 10 milligrams of amitriptyline that was recently increased to 20 milligrams, but there's no real evidence of whether or not she actually increased that dose. And then it was a low dose of trazodone and a low dose of, I believe, Valium. So those were prescribed medications that she had reported no side effects from, and I believe in the text with her mother, she said that she was still waiting to actually feel effects from those. So there's no evidence of intoxication from those drugs. And then the only intoxication potentially could be when she took pills after killing the children. And even those amounts from the toxicology are low-level amounts. So we're asking that the instruction on intoxication not be given.
Let me ask you this. I'm going to ask the defendant as well, because I did read through those. And I was trying to find the definition of intoxication as it applies in the homicide instructions. Most of the cases that I was able to find so far is the dealing with the OUI statute, Chapter 90, and trying to find the real definition in regards to that. Is it the Commonwealth's position that the intoxication is beyond what was the considered effect of the drugs? Because if do you know what I'm saying? So if she takes, if a defendant, I don't mean to personalize it, if a defendant takes prescription drugs and it does create some effect, would that be considered intoxicated for the instruction?
I don't believe so. I think in the instructions it talks about having being intoxicated to the point where it affects your state of mind or ability to control yourself. I think intoxication, especially where there's not a specific definition given in the homicide instructions, I think you go to the general definition of intoxication, which would not just be taking medication as prescribed, but it would be over taking medication or combining with alcohol or other drugs. similar to the instructions in OUIs, operating under the influence of alcohol or drugs. I think you would have to go to that definition or to the general definition of intoxication if it's not specifically defined in the instructions. And I think the general definition of intoxication is taking some type of substance, either alcohol, drugs, medication, in excess, and to the point where it's affecting your ability to think and to act and to control your behavior.
All right. All right. Anything? So I've got opinion, prior, consistent, prior, inconsistent, redaction, stipulations, consciousness of guilt, first, second, extreme atrocity, deliberate premeditation, and the criminal responsibilities without the subparagraph or the paragraph regarding intoxication.
Correct.
Okay. All right. Mr. Reddington?
I don't know if the government has been listening to the same evidence in this case. This is clearly an involuntary intoxication defense, at least as far as the judge's charge to the jury, based upon the evidence that's been presented, whether or not it's what we would argue is the over prescription of the medications, whether or not it's the side effects of the medications, whether or not it's the titration or the termination or the immediate cessation of the medications against what normal medical advice would be. All of those factors contribute to the state of mind of Ms. Clancy that was expressed to a lot of people, family members, people that knew her. She had indicated, I think Your Honor knows the evidence, repeatedly indicated that she was affected by the benzos. She was felt that she was being addicted to the benzos, trying to get off the benzos. She indicated that the sertraline was obviously killing her as far as going from 25 to 50 milligrams, and then subsequent to that, when there's additional SSRIs prescribed. To suggest that there's no basis to give the jury the instruction, they may determine, based on the evidence, that is as a result of the involuntary intoxication from narcotics, not alcohol, obviously, from the prescribed narcotics, not illegal drugs. So from the prescription drugs, that's on all fours with a valid defense that they should be instructed as it relates to involuntary intoxication. I think it's the model jury instructions on criminal responsibility. Obviously, if there's any nuances that I would pick up, I would bring that to the court's attention. But I have tried murder case recently with the model jury instructions, and my memory is that I was pretty satisfied. It was Judge O'Shea, I think, actually in this courtroom a year ago, and I was satisfied with the instructions on lack of criminal responsibility. I would, at some point, ask the court to charge on involuntary manslaughter. I'd ask the court to charge on wanton conduct with a component of the impact of the intoxication. So you can't try this case in a vacuum. You can't present the case to the jury. I know the government would like to present the case only on cruelty and atrocity. They probably don't like the statute that allows a jury to determine the degree of murder, which would be first and second. But I think that the evidence is such that a jury should have the option of considering whether or not we're talking about involuntary manslaughter based upon the evidence that's permitted. So I would defer to the court on the instructions on cruelty and atrocity, premeditated malice aforethought, second degree malice. I would ask the court to consider instructing on involuntary intoxication, to consider on the involuntary manslaughter as a lesser offense, and anything else that I can think of. But right now, that's what I can think of.
All right. Yeah, counsel.
Thank you. The Commonwealth did request first and second degree instructions. It's our position that involuntary manslaughter wouldn't apply here. The evidence is that there was a specific intent to cause the death. So there's nothing that I can think of in the involuntary instruction that would apply here. Going back to the intoxication just for a moment.
Sure.
All of the medications, most of the medications that defense counsel talked about that the defendant was having reactions to and side effects from were before her hospitalization at McLean Hospital, and she was weaned off of that last one, the Seroquel, that while she was in McLean Hospital, and then she was without those medications, and they're out of her system for 3 weeks, and she's just on those other 3 medications. So the intoxication that matters is not what happened in the fall and before McLean, it's what happened on the day of the incident. It's similar if it's an OUI, it doesn't matter if you were drunk in November, it matters if you're drunk on the date of the incident. So what matters here is that January 24th, 2023, and those other drugs and the effects that they caused to her aren't relevant to what happened on that day, as they've been out of her system for at least 3 weeks at that point.
All right, so the Commonwealth's position would be that the relevant analysis is what she was taking on or around that January 24th?
Yes.
Okay, all right. All right, any other?
Yes.
Yeah, good, sure.
It occurred to me, again, as I said, it's only fresh in my mind from a case I had here last year. I know the model jury instructions indicate, and I'm trying to find it in here, that there's supposed to be consideration of a chalk for the court to write out the elements of the offense of first-degree murder, cruelty and atrocity, premeditated malice of forethought, etc. And I would ask that you not do that. I don't think that it's appropriate. I think it highlights, if you will, in simplistic terms, premeditated malice of forethought. I think you and I, we just had a murder case last year on another matter, and I mean, I heard your instructions. You're very forceful with the elements of the offense, and I just don't think we need to have this appendix or whatever you want to call it. And again, I did object to that with the Judge O'Shea. We did not submit the instruction list, cookbook, or whatever you want to call it, to the jury. So I think that the court's instructions would be sufficient. I would not want to have that chalk that is referenced in the model instructions. That's discretionary. It's not obligated. They just say that it might be helpful for the court to give the jury some type of a checklist. But I don't think we should reduce instructions on a murder case to a checklist. And I'm just afraid that what happens is that jurors then take the checklist, as it were, and they kind of look at it or consider it, and they just do exactly that. It's a checklist. So I would ask that you not do that.
All right, just so Counsel, my general practice is not to have that kind of list. I generally don't, but I also generally will provide a copy of the instructions to each juror. So they'll have their own full copy, and they can follow along, because the 3 of you know they're lengthy and kind of dry. So they'll have those with them. But I'll like I said, I generally don't do that chart. All right, so anything else in regards to the instructions?
No, Your Honor.
All right, so my plan would be to have at least a rough draft available for counsel tomorrow. So you at least have that, and depending on the timing and where we go in regards to the actual closings, we'll have the opportunity for you to review those, go over the draft, and then any kind of objections or suggestions you want to make, we'll have a chance to do that. But so you'll have, again, it's a rough draft. That's all I can tell you, and nothing's in stone, but at least give you an idea kind of where I'm coming from.
Do you think, logistically, Your Honor, that with the presentation of Dr. Resnick and then the government having their 3 doctors, hopefully we finish the evidence tomorrow, we would be closing Monday?
I would expect either Monday or Tuesday. I mean, if the parties may need, we could talk about that. But, my old experience, there's been a lot of evidence, and there's a lot of witnesses. And so if the parties feel that they need like a day to kind of marshal their thoughts, we could talk about that. So either probably Monday or Tuesday. We could talk about that tomorrow. All right? All right, anything else we need to address, you think?
No, Your Honor.
All right, and so tomorrow we'll be in recess until tomorrow at 9 o'clock. Hopefully we'll start with Dr. Resnick, and then, correct?
Yes.
Yeah, all right. You just kind of looked, I thought, so that would be the thought. and then we'll just kind of go from there. If the defendant rests, the Commonwealth can then present their witnesses, and if it's not done by Friday, we go into Monday, and that may mean closings and charge on Tuesday.
Okay.
All right.
And Mr. Verino will be here, yes, to set up the Zoom.
So you're not going to trust me to set that up this time? I think that's a good move.
Oh, me.
All right. All right. So thank you, everyone. And so we'll be in recess until tomorrow.
Thank you.
Thank you.
Court, all rise.
show support for Lindsay and for Kevin Reddington, who's amazing.
We're here to support Lindsay and also all the women in America who's gone through our healthcare system and has been diminished and let down. I'm also a mental health worker for 15 years, and I'm here to support Lindsay, her children, and I hope she gets the help she needs. Massachusetts failed her, and we need to stand and show people that mental illness is a serious thing, and more women need support.
A crowd in pink in Plymouth, Massachusetts. But what's going on inside of that courthouse? Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us on this Thursday. Interest is steadily growing. You see it there in the murder trial of Lindsay Clancy. We've also seen a crowded courtroom today, but the defense case appears to be winding down. The defense has not officially rested its case in front of the jury, but we understand that they are close to that. We saw a witness take the stand today, and these jurors went home early for the day. Rebuttal witnesses are likely going to be taking the stand tomorrow and Monday, but there could be closings on Monday. We will see, and then we would be in that verdict watch. So much is moving rapidly there inside of that courtroom. As for now, we're going back in because, as I mentioned, the jury has been sent home for the day, and these attorneys are using this time to handle jury instructions, and they're talking about voluntary versus involuntary intoxication. Let's pick it up where we left off.
And I was satisfied with the instructions on lack of criminal responsibility. I would, at some point, ask the court to charge on involuntary manslaughter. I'd ask the court to charge on wanton conduct with a component of the impact of the intoxication. So you can't try this case in a vacuum. You can't present the case to the jury. I know the government would like to present the case only on cruelty and atrocity. They probably don't like the statute that allows a jury to determine the degree of murder, which would be first and second, but I think that the evidence is such that a jury should have the option of considering whether or not we're talking about involuntary manslaughter based upon the evidence that's permitted. So I would defer to the court on the instructions on cruelty and atrocity, premeditated malice aforethought, second degree malice. I would ask the court to consider instructing on involuntary intoxication, to consider on the involuntary manslaughter as a lesser offense, and anything else that I can think of. But right now, that's what I can think of.
All right. Yeah, counsel.
Thank you. The Commonwealth did request first and second degree instructions. It's our position that involuntary manslaughter wouldn't apply here. The evidence is that there was a specific intent to cause the death, so there's nothing that I can think of in the involuntary instruction that would apply here. Going back to the intoxication just for a moment.
Sure.
All of the medications, most of the medications that defense counsel talked about that the defendant was having reactions to and side effects from were before her hospitalization at McLean Hospital, and she was weaned off of that last one, the Seroquel, that while she was in McLean Hospital, and then she was without those medications and they're out of her system for 3 weeks, and she's just on those other 3 medications. So the intoxication that matters is not what happened in the fall and before McLean, it's what happened on the day of the incident. It's similar if it's an OUI, it doesn't matter if you were drunk in November, it matters if you're drunk on the date of the incident. So what matters here is that January 24th, 2023, and those other drugs and the effects that they caused to her aren't relevant to what happened on that day, as they've been out of her system for at least 3 weeks at that point.
All right, so the Commonwealth's position would be that the relevant analysis is what she was taking on or around that January 24th?
Yes.
Okay, all right. All right, any other?
Yes.
Yeah, good, sure.
It occurred to me, again, as I said, it's only fresh in my mind from the case I had here last year. I know the model jury instructions indicate, and I'm trying to find it in here, that there's supposed to be consideration of a chalk for the court to write out the elements of the offense of first-degree murder, cruelty and atrocity, premeditated malice aforethought, etc. And I would ask that you not do that. I don't think that it's appropriate. I think it highlights, if you will, in simplistic terms, premeditated malice aforethought. I think you and I, we just had a murder case last year on another matter, and I mean, I heard your instructions. You're very forceful with the elements of the offense, and I just don't think we need to have this appendix or whatever you want to call it. And again, I did object to that with the Judge O'Shea. We did not submit the instruction list, cookbook, or whatever you want to call it, to the jury. So I think that the court's instructions would be sufficient. I would not want to have that chalk that is referenced in the model instructions. That's discretionary. It's not obligated. They just say that it might be helpful for the court to give the jury some type of a checklist. But I don't think we should reduce instructions on a murder case to a checklist. And I'm just afraid that what happens is that jurors then take the checklist, as it were, and they kind of look at it or consider it, and they just do exactly that. It's a checklist. So I would ask that you not do that.
All right, just so Counsel, my general practice is not to have that kind of list. I generally don't, but I also generally will provide a copy of the instructions to each juror. So they'll have their own full copy, and they can follow along, because the three of you know they're lengthy and kind of dry. So they'll have those with them. But I'll like I said, I generally don't do that chart. All right, so anything else in regards to the instructions?
No, Your Honor.
All right, so my plan would be to have at least a rough draft available for counsel tomorrow. So you at least have that, and depending on the timing and where we go in regards to the actual closings, we'll have the opportunity for you to review those, go over the draft, and then any kind of objections or suggestions you want to make, we'll have a chance to do that. But so you'll have, again, it's a rough draft. That's all I can tell you, and nothing's in stone, but at least give you an idea kind of where I'm coming from.
Do you think, logistically, Your Honor, that with the presentation of Dr. Resnick and then the government having their three doctors, hopefully we finish the evidence tomorrow, we would be closing Monday?
I would expect either Monday or Tuesday. I mean, if the parties may need, we can talk about that. But, my old experience, there's been a lot of evidence, and there's a lot of witnesses. And so if the parties feel that they need like a day to kind of marshal their thoughts, we could talk about that. So either probably Monday or Tuesday. We could talk about that tomorrow. All right? All right, anything else we need to address, you think?
No, Your Honor.
All right, and so tomorrow we'll be in recess until tomorrow at 9 o'clock. Hopefully we'll start with Dr. Resnick, and then, correct?
Yes.
Yeah, all right. You just kind of looked, I thought, so that would be the thought, and then we'll just kind of go from there. If the defendant rests, the Commonwealth can then present their witnesses, and if it's not done by Friday, we go into Monday, and that may mean closings and charge on Tuesday.
Okay.
All right.
And Mr. Verino will be here, yes, to set up the Zoom.
So you're not going to trust me to set that up this time? I think that's a good move. All right. So thank you, everyone, and so we'll be in recess until tomorrow.
Thank you.
Thank you.
Court, all rise.
A short day in Massachusetts today with defense case still going. And we hear there what's going to happen on Friday in terms of the final defense expert taking the stand, Dr. Philip Resnick. And then the prosecution will have their rebuttal witnesses. We understand there are going to be 3 medical experts that they will be bringing to the stand. But that's it for the day there in Plymouth County. Let's bring in our guests to talk about where we are in the Lindsay Clancy trial and what we can expect. A fantastic panel here with us today. We have joining us former Deputy Public Defender of LA County, Philip Dubé, and trial attorney Randolph Rice, and law enforcement and litigation expert Sonny Slaughter, all with us. So good to see you all on this Thursday. Philip Dubé, I'm going to start with you. That jury instruction request by the defense attorney about it not being a checklist. I'm seeming to remember there being a question about the verdict form and the way that it was listed in the Karen Reed trial. That sometimes comes up for defense attorneys. They want these verdict forms to look a certain way for jurors because Explain to us why defense attorneys think they may be swayed just by the order of things on that verdict form.
Well, first of all, and I think we've talked about this in previous shows, Julia, where if jurors do not follow the strict letter of the law, namely the instructions in a very specific chronological order, if they, for example, start deliberating on a lesser included offense and reach a not guilty, it could bar further deliberations on the greater. In other words, it could operate as an acquittal of the greater offense. And certainly that's not the spirit and the intent of the drafters of these jury instructions. They want them to go through them methodically and in a certain order to make sure they don't get to the wrong result. And yes, we saw that in sort of off-the-record challenges and discussions in the Karen Reed case, where in fact they announced that they were deadlocked, but nobody really went behind that deadlock to inquire as to whether or not a verdict had been reached on other charges. So for example, a lesser included offense. So you have to kind of, I hate to say it, you got to kind of dumb it down a little bit and make it digestible and understandable for mass consumption. Because in the end, that's what jurors are, frankly. They are the masses. And if we're honest about it, Julia, even lawyers and judges get tripped up with these jury instructions. Sometimes they are so confusing and difficult to understand that you really have to break it down in layman's terms.
No, absolutely. Randolph Rice, if you're defending Lindsay Clancy, in your closing argument that we understand, the judge is saying Monday or Tuesday, we could be in closings. If you're the defense, are you going to hint at all at any lessers? Or are you going to 100% lean into not guilty, not criminally responsible due to mental illness?
I think that probably consumes 80 to 90% of your argument if you're the defense here and during your closing. And because that is such a key part to this, at the end of the day, we talked about this a little bit last hour, I don't think that the defense is here looking for a hung jury or flat out not guilty. I think they want that not criminally responsible, that insanity finding, and therefore Lindsay Clancy goes to a mental health facility and not to the Department of Corrections for Massachusetts. So I think they spend 80 to 90% of that. There's always that ability, though, to say, look, if you don't, in the alternative, you have the option of finding that lesser offense, that involuntary manslaughter by wanton behavior. So it's a slither, but it's not the main thrust of your argument.
Yeah, I'm very anxious to see these closing arguments, Sonny, especially because I don't think I believe that there are things that we have not seen from the prosecution that we are going to hear in their closing arguments. I think the way that they are going to sum this all up and share their entire theory of this case is going to be something new. What are you anticipating in these closing arguments that are going to be Monday or Tuesday?
Hi, Julia, and hi, Philip. Listen, I think this is going to wind up being what you just said. The prosecution is going to say, this is the theory of the case. They're going to lay it all out. They may change some things, but I'm not sure, because the prosecution keeps focusing on things that I think are irrelevant and really make their case watery. For the defense, I just think that Reddington wants the jury to make a decision. That's why he has not called for any mistrials or anything else during his presentation and during this defense. He just wants this case to be over and done with it in the best possible light for Lindsay, and I think that's what he's going to go for. And next week is going to be the final decision in this case. Until we see what happens, we're just going to have to keep staying focused on every detail.
Yeah, interesting observations. Sonny, Philip, I don't want to get too far ahead of ourselves. We still have a full day tomorrow, a day of doctors. We're going to have at least 4 medical experts on the stand if they can all get in. What do you think is left to be explained in the defense case? What needs to be drilled down a little more? I do believe Kevin Reddington has been very efficient with the time of his experts on the stand. We haven't had any witnesses that have taken up a half a day or a full day. Dr. Resnick, he's going to be the one that he's ending on, so there may be some importance to that or strategy to that. But tell me what you think still needs to be explained more to these jurors.
I think common jurors need to understand that this form of psychosis not only is an emergency and can come on without any outward symptomology, but that you could appear to be an otherwise functioning human being, be linear, be employed, you can drive, take your medication as directed, you can provide for your own care, your children's care, and still suddenly be psychotic. And that the psychosis can completely overcome the human mind to the point where you enter into a wayward delusional system and you suffer from auditory and visual hallucinations. And unless you can kind of weave all that together, she's going to look like a cold-blooded killer waiting for the right moment to strike when he left the house. So jurors need to understand and be able to piece that together, not just clinically, but also forensically.
Yeah, we certainly may hear that from Dr. Resnick when he takes a stand, the forensic psychiatrist. We've got to slip in our break, but we aren't done talking about Lindsay Clancy. Our panel is coming with us. We're on the ground there in Plymouth, Massachusetts. That crowd of Pink supporters has still been growing, and we're going to talk more about that and the impact of this trial after the break.
So I don't want to say what happened. I know that she needed help.
What do you think is going to happen?
I hope she get the help that she needs, and that the world get educated and informed about mental health and a woman's mental health, because that's real.
Those are the sights and sounds from the Stand in Peace for Lindsay Clancy rally that happened this morning in front of that courthouse. Inside of the courthouse, we expect the defense to rest its case tomorrow in the murder trial for the former nurse who admits to strangling her 3 children to death. But her defense says that she was suffering from postpartum psychosis. Court just wrapped up completely for the day a short time ago. But this morning, hundreds of women and some men were up early in support of Lindsay Clancy. They gathered outside of that Plymouth County Courthouse at exactly 7:45 a.m. They stood in silence. Many of the women expressed not only their support of Lindsay, but also their concern over, you heard from that woman that we just heard from, mental health treatment in general. Lindsay's defense attorney, Kevin Reddington, also made an appearance to the cheers of the crowd. He thanked everyone for their support. Take a listen.
Mr. Reddington, what's your message to all these folks who are here today?
Thank you. That's all I can say. It's amazing.
We love you, Kevin.
Kevin, are you surprised at just how much attention this case has gotten? I mean, people are coming from Maine.
It's the message. It really is. It's the message that just has reverberated, throughout the whole country.
What is that
Reddington's
message?
fighting for women's rights.
No, I
for
don't.
healthcare.
I think that it's the mental health system. I hate to use the word health care because, unfortunately, in this case, we can see it hasn't been health care, and I think that it shines a light on this issue. I mean, when a woman is going through what so many people do, and they go to a doctor, and the doctor says, here, take this pill, take that pill, take this pill, and then they basically treat them for 15, 20 minutes and send them on their way. It's just not right.
And to those who can't wrap their heads around sympathizing with a mother who killed her 3 children, what do you say to them?
I think it's almost like when you're picking a jury, and sometimes somebody will say, well, I don't agree with, this allegation of murder. I mean, none of us do. But that's what we have juries for. They pass between the government and a defendant to see if they can prove their case.
But is she aware of this support, and what does she think of this support?
I'm going to go in and see her right now. I'm sure that she is, and if she isn't, she will be.
What do you think about?
She's so beat up and just so sad that this will really help her out, I think. It's awesome.
Tell her we love her. What do you think about you being the advocate for all women right now?
I'm not an advocate.
You are. But you are. But you are.
What a scene there in Plymouth County, Massachusetts. Kevin Reddington there giving his comments in front of all of those media outlets. And you might have noticed, we noticed here, former Court TV correspondent Chanley Painter there with the microphone in front of him. But just an idea of how many people are interested in hearing what's happening inside of that courtroom. Let's bring back in our panel. Former Deputy Public Defender of LA County, Philip Dubé, is with us, trial attorney Randolph Rice, and law enforcement expert Sonny Slaughter. Philip, just react to the idea of all of these people coming to show support for a defendant who has killed her children, who admits to killing her children. Have you seen anything like that?
Oh, we saw a sea of pink in the Karen Reed case. Don't you remember? They all went out there rallying in support of her and against police corruption. That was the sentiment in Canton, Massachusetts back then. And ironically, here we are back in Massachusetts rallying for another criminal defendant charged with triple filicide. It's remarkable. But at the end of the day, if we're all honest, this is really a referendum on health and wellness. And I think there has been a sea change in this country about how we perceive the criminal mind if it is in fact diseased by a mental defect. People just are sick and tired of inadequate physical and mental health care and holding people accountable for their crimes that were beyond their control here. So that's going to be the issue. And this is a delicate dance, to be fair to the court, because on the one hand, you don't want to interfere with the peaceful right of assembly and freedom of speech, but under the First Amendment. But by the same token, you got to protect jurors from outside influences. You don't want this public to somehow coerce a verdict, and you want them to reach a fair and final verdict on the merits and not based on perceived public pressure.
Sonny Slaughter, first of all, I want to mention that the flags everyone is holding, we understand that they are doing that to represent all of the countries where there has been support in some way, likely on social media, for Lindsay Clancy. But what do you think about what Philip just mentioned, that this is an area that has already seen this kind of reaction to a case that's not necessarily a celebrity case? It's a high-profile one, though, nonetheless, and we've got the sea of pink in support of a defendant.
Look, I just realized that I was wearing pink, and that was definitely not intentional of wearing the pink, but Massachusetts is giving us a lot when it comes to laws and lessons, from Karen Reed to now this particular case. And I saw Bob Mata out there as well. He's live covering the case. I just saw Chanley. It's such a difficult case, but you know, two things can be true. We can definitely be upset and hurt by the fact that 3 children are no longer with us, but we can also have respect, responsibility, and a level of understanding around mental health, disease, and diagnosis, and then how quickly things can happen. Philip has taught me so much privately and professionally watching this particular case around how quickly psychosis can come on, and understanding it more, and talking to other colleagues around psychosis, which is not even recognized because it doesn't happen as much. I know about postpartum depression. I had it. My daughter just had a baby. But so many people are angry. And to see this level of support, they're supporting Lindsay because they recognize that she had a problem. They're not supporting what she did. And I wish people would think more about that. Being able to separate the two is really important. And that's what this jury is going to have to do.
Sonny, you're hitting on a really important issue. And I've seen this from the people who are watching. It's the minority of folks, but people who are asking, how do we hold the space for both understanding that mental illness is real and needs more attention in society, but also that there has to be accountability? And Randolph, I'm going to ask you, because I'm going to compare this to some other high-profile cases, but those involving fathers. We have Chad Dorman, who killed his 3 sons. He pleaded guilty for that, but he said he was doing it for God. He wasn't acting like himself. He was carrying around a Bible at the time. And we have Travis Decker, who was found deceased, but believed to have killed his 3 daughters. And he had personality disorder. He was diagnosed with that at the time. He was homeless and estranged from his wife. No one is excusing what they did due to their mental illness. Is that a problem?
No, I think Sonny said it well. Like, both things can be true. And let me just tell a quick story. That I was at a party last night, and a woman who knew that we'd been on talking about this all week, the Lindsay Clancy case, she came up to me and she said, you know, I have to tell you a quick story. I had 3 kids very close to each other years ago, and I came to a moment where I literally could not get out the door. I broke down crying. I had to call my husband because I needed to go out and get toilet paper. That simple thing. And she actually started crying last night as she told me this story. That's the kind of woman who's outside of this courthouse right now, because they feel the same thing. They have had depression. They had the blues. They understand this. And Sonny obviously told the same story. The men, I think there's a little bit different thing there. You know, the Chris Watts story, the case years ago. Obviously, there's not the postpartum depression or psychosis. There's some other mental health things here. But Sonny said it right. Both things can be true. You can do a horrible thing and we can punish you or take care of that, but you can also have this mental health condition that we need to deal with. And in this case, the result is probably going to a mental health facility for a very, very long time.
Philip, we've got a jury of 12. No doubt there's going to be sentiments that we're all expressing here and that we're seeing the diversity of it online. If you've got multiple jurors feeling differently about this case, what do you think the outcome is going to be? How do they approach this if there is this understanding that postpartum psychosis is very real, but they also want to see accountability? What do you think a conviction looks like?
In the final analysis, Julia, the defense has to prove that she was unstoppable. Everybody is going to be in unison on this idea that she suffered from a mental disease, sort of a dual diagnosis of bipolar disorder along with the PPP, the postpartum psychosis. The question for the jury is whether or not she was able to and chose not to stop herself. And I think they're going to deadlock. That's just me. I think you're going to get a percentage of jurors who feel that she had enough wits about her and volitional control to halt.
What's the
and chose
compromise
not
vote,
to.
Philip? What do you think the compromise, if they decide to split things, what do you think that looks like?
Well, if they compromise things, then it means you have to retry the case, because the only split you can reach is criminally responsible or not criminally responsible, and depending on which way they go is a housing matter. Criminally responsible means she goes off to prison in a wheelchair. Not criminally responsible means she goes off to the booby hatch, frankly, in a wheelchair, the hospital for the criminally insane. If they are not in unanimity on that issue, then they have to retry the case. And I am hopeful that if it hangs, Mr. Reddington might be able to enter into negotiations with the Commonwealth to plead her out, but to a finding of not criminally responsible, so they don't have to retry her, and instead she goes off to the hospital, and that'll resolve the matter.
Great discussion, everyone. We do have to get to a break, but we are going to keep talking about this case. Also, there was a quick witness who was on the stand today that left us with a lot to talk about. We're taking a closer look at the chaplain who spoke to Lindsay Clancy after the killings and what she said Lindsay Clancy revealed to her. Stay with us. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us this hour as we are focused on the Commonwealth of Massachusetts, particularly Plymouth, Massachusetts, where we've been on the ground for the Lindsay Clancy murder trial. Court adjourned for the day. It's day 17. It was a short day. This all happened moments ago. We are still there monitoring any developments. The defense only called one witness to the stand. She was a hospital chaplain who met with the defendant right after she killed her children inside of that hospital while she was still restrained and being watched by security. Take a listen to what she said about Clancy and what she revealed to her when she asked her about what happened.
Did she make any other statements to you?
She did. She alluded to having heard a voice. And the voice, according to Lindsay, told her that if she did not follow the command, neither she nor her children would be safe.
And did she indicate whether it was a male voice, a female voice, loud, soft?
She alluded to the fact that it was a male voice and it was persistent.
Any further conversation that you recall about that, not about general things,
That came up several times. I visited Lindsay.
And in all of these notes that detail every time you interacted with her, you never once wrote that she told you she heard a voice or what that voice said, correct?
Correct.
And you also said that this voice, talking about the voice, came up in several of your meetings, correct?
Correct.
And you never once wrote about any of it in any of your very detailed notes, correct?
Well, chaplain notes are not verbatim transcripts of patient conversations. I'm not there to evaluate the patient. I'm there to bear witness to their suffering.
Okay, but the question was you did not document those statements in your notes, correct?
Correct.
Well, let's bring back in our panel. Philip DeBay, Randolph Rice, and Sonny Slaughter are all with us. Sonny, when I heard this board-certified chaplain on the stand, and she said that about Lindsay revealing to her that she had heard voices, I thought this was the last witness for the defense. I thought this was a great note for them to end on because there have not been a lot of people who've been able to corroborate this hearing of voices.
Yeah, I agree. I thought that was a very important point to their case, but then I listened. I heard what she said, but then I listened, and the prosecution brought out the fact that she did not document that she documented so much of the other parts of the conversation, but not that, and that's where I thought it became problematic for her. Because it's really important. If you're going to document most things, and she might not have documented everything, but that was a critical part, but she would not have known necessarily that may have played a role if she's not communicating with with Reddington or anyone else. So,
Randolph Rice, what did you think about the chaplain on the stand?
Well, first off, she had an interesting demeanor, and I'll sort of leave it at that. I found it to be a strange body language, a little over prepared. The way she answered questions looking at the jury, which is nothing wrong with that. And I tell all of my witnesses, look at the jury, make the connection, make that eye connection. But for some reason, and as Sonny said, like all these important things that you were told, you wrote down a lot of very important things, but this seems to be an important thing. And not once did she tell you this, but Lindsay told you multiple times that she'd heard this voice. Why was this not documented? I almost wonder, does this hurt the credibility of the defense and that argument they're trying to make that there is a voice that she heard? Does it hurt them by pushing too hard with this witness?
Credibility is important here, Philip, and we're going to listen back to a clip because Dr. Zeisel, their forensic psychologist, who also met with Lindsay very early on, the prosecution has hinted at, investigators have hinted at, he possibly gave this information to Lindsay, that he was coaching her, that he let her know if you heard voices, then this was psychosis, and that was the first time anyone heard her say anything about voices. Let's take a listen back to his testimony.
Tell us what she said to Patrick in your presence on the speakerphone at that point.
She had told Patrick that she loved him very much. She was unable to express a lot of emotion, but she expressed love for him, and she had said that she heard a male voice ordering her, telling her that she didn't have any choice, but she had to kill her children and then kill herself.
Philip Dubé, no other medical provider noted this. Anyone who was treating the defendant prior to, they don't have it in their notes at all. And even Patrick said he never heard her say to him that she was hearing voices. Yet once she meets with this forensic psychologist, that's when she tells Patrick about the voice. He denies that there was any kind of coaching. He says this was voluntary. It came out in this phone call. Do you think having the chaplain really corroborated almost perfectly to Randolph's point? Do you think it hurts the defense at all?
I don't think it hurts. I actually think it helps. And this is where it requires a complicated discussion. We probably don't have enough time about the distinction between a treating doctor and an appointed or retained expert. When you have a treating doctor, that means you have an ongoing treatment protocol, treating relationship with either a mental or psych provider. And they're there to listen to your symptoms, analyze you, and try to come up with some type of treatment plan for you, including hospitalization if necessary. Contrast that with a forensic expert. There is no doctor-patient or psychotherapist-patient relationship. Instead, it is an arm of the attorney-client relationship, meaning that expert is hired to aid in the defense of a specific person. So what does that mean? It means that when you are not a regular treating doctor, the first thing the expert has to do is gain the trust and confidence of the client. So they know who you are, where you're coming from, and what your role is. And you tell your client, as a treating type expert, if you will, or an analyzing expert, why you have been retained and what your role is, what type of testing you're going to be doing, and not explain what type of outcome you want, but objectively explain what it is that you're going to be doing. And if in that process you drop a few clinical or forensic terms like psychosis, postpartum, depression, you start mentioning drugs, it's all part of that expert relationship. So it's not about coaching or trying to plant seeds or put words in the defendant's mouth. It's about educating them to build the trust and the confidence further in the attorney-client relationship.
Philip, are you saying that
should have
he
been developed.
educated her on voices, or he educated her? I want to make sure I'm understanding, because I think this is important.
No, on the science. On the science. So he was explaining his role, why he has been retained, what the purpose of it is, what he'll be doing, and that's that. So that way, at least she doesn't distrust him. You got to understand, when you're locked up and some stranger is coming to see you, you don't know who they are. You don't know if they're the cops, if they're working for the DA's office. Obviously, Mr. Reddington must have told her ahead of time that an expert's going to come and see her. But nonetheless, you are still very distrustful of the world. So it goes back to what I said earlier. You have to gain their trust and confidence. You talk to them a little bit, explain to them what your role is and what you'll be doing. And in that process, you'll be using some of the psychiatric lingo that you might hear in a forensic examination, but not to plant seeds. It's really to kind of fine-tune the relationship.
Yeah, certainly something that the defense had to explain to these jurors about his role, but he denies any kind of coaching of the defendant. And we had the chaplain who was saying some of the same things that he heard from Lindsay Clancy in the same hospital setting. Let's get to our break. We've got a lot more to talk about, including the mentioning of another high-profile case involving postpartum psychosis and the killing of children. It's actually come up in this trial. Don't go anywhere. Thank you for being with us as our continuing coverage goes on in Plymouth, Massachusetts for the trial of Lindsay Clancy, a mom on trial for the murder of her 3 children, where her defense says that this was a situation where she did not know right from wrong in the moment, that she was suffering from postpartum psychosis. This trial has had us thinking about other similar cases with the big question of how a mother could kill her own children. Clancy certainly isn't the first defendant to do something this terrible, but it doesn't make the facts of the case any easier to understand. Many are drawing the comparison of this case to that of Andrea Yates. Earlier this week, a nurse who worked with Clancy testified about the defendant's reaction to hearing about this case long before Lindsay Clancy would be arrested.
We had a conversation. Lindsay was brand new. It was the summer that she had just started. And we had a conversation about mental health in pregnancy and postpartum. And I asked her if she had ever heard of the Andrea Yates case, and she hadn't. And I explained that to her, and she cried. And she said, how could a mother hurt her children?
In 2001 is when Yates drowned her 5 children and claimed postpartum psychosis and other mental health illnesses. The first jury, though, convicted her, found her guilty. And it's not until an overturned conviction and then a second jury finding her not guilty by reason of insanity, leading her to live a life in a mental health institution. Let's bring back in our panel of legal analysts who are still with us, Philip Dubé, Randolph Rice, and Sunny Slaughter. Randolph Rice, let's talk about that moment inside of the courtroom where Margaret Ham, who was a former co-worker of the defendant, testified, and it was brought up on redirect. The prosecution opened the door during cross. Who do you think that moment helps, knowing that at some point in Lindsay Clancy's life, she heard about this horrific crime and felt strong emotions about it?
Yeah, it certainly helps the defense. And it's just one more piece of the building blocks in establishing that she was a good mother. She loved her children. She would never want anything bad to happen to them. And that goes along with all the other things that she was doing up to the moment that she killed them. I mean, you know, making snowmen that day, worrying about their medications, you know, all the things that the witnesses testified to about how she was a good mother, despite the fact that she was suffering for this. And I don't think there's any doubt that this was postpartum depression up to the moment of the psychosis, which, you know, that's obviously what the defense is arguing, when she did have this snap and ultimately killed her kids. One other quick note that I wanted to just say based on our conversation earlier was there's a third option, but this jury could come back. I don't think it's very likely, and I'd love to hear Philip's opinion on this, but they could come back and say not guilty altogether. That's a third option there. Not very likely, but still an option.
Yeah, Philip, react to that.
Well, that would then be jury nullification, because it's undisputed that she killed the kids. Unless you've got some conspiracy theorists on that juror who think she's covering for somebody else, she did not have a hand in it, you know, that's one thing. But if they feel that this prosecution, even though it was lawfully brought, should never have been brought, and they're going to just disregard the law, then their message is to send a message to the Commonwealth that they had no business bringing this case, that this case did not belong in the criminal justice system. And ample precedent for it in history. That wouldn't surprise me. And you never know. You never know.
Sunny Slaughter, I want to read you something back to the discussion about Andrea Yates, that Texas case, and the comparisons, because we definitely know more now about postpartum psychosis and depression than we did back in 2006, 2010, 2001. But the attorney for Andrea Yates spoke with Court TV. You can go and find that article on our website, courttv.com. But George Parnham said that just because a mother waits for the husband or father to leave doesn't necessarily mean she's not in a psychotic break. That happened in both the Yates case and the Clancy case. And something that Parnham emphasized to the jury is that even though she was in the grips of psychosis, Yates believed that she knew what was best for their children, and she knew that the husband would try and stop her from what she knew would be best. Do you think that Kevin Reddington has emphasized that enough through these witnesses, that in this psychotic state, perhaps Lindsay Clancy believed that this was the best route for her children? As horrible as that is to say, I'm wondering if the comparison of these two cases, whether or not he's going to take a similar approach in closing.
I don't think I've heard that enough in this particular case, whether she knew best for her children and whether the comparison with the Andrea Yates case and this one, but I do think it's a reasonable route to go down for more discussion. And let me say this, in addition to postpartum, we talked a lot about medication, but one of the other things that women have during postpartum depression and psychosis, because we know that they are so closely aligned, is the different hormones. The hormones that women are having, the fluctuation of hormones, medication. I know there's been some conversation around, well, she didn't have enough in her system and that she didn't talk about all of the medications that she was on. We also haven't talked about the non-prescription medication that could potentially impact the medication that she was taking. So there are a lot of thorough ways for people to really analyze this case in a way that is not so linear that they only focus on the fact that she murdered these children and that she is evil, and less about all of the other intersecting possibilities around mental health, medical conditions, hormones, non-prescription medication, and just the overall condition that she was in. People operate every day experiencing mental health disease and diagnosis, and then they just have a potential break. My daughter was in the store and we were shopping, and all of a sudden she started crying. That's problematic.
And I think that's the sentiment that a lot of those people who are outside of this courthouse in that rally, that they are feeling and want to be seen on, and they believe that this trial is the case for that. Thank you so much to this panel, Philip Dubé, Randolph Rice, and Sunny Slaughter. We appreciate your time and your expertise. We have a lot more ahead. Don't go anywhere. You're watching Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us on this Thursday. We are 1 day away from the defense for Lindsay Clancy resting its case. This as interest in the case appears to be steadily growing both inside and outside of the courthouse. In the gallery today, we noticed this crowded courtroom, and then outside there was a rally held with hundreds of people wearing pink in support of Clancy. Now, the defense has not officially rested its case. They have one more witness. They only called one witness to the stand today, and after that, they had a charge conference and everyone left the courtroom early. We understand that tomorrow we're going to hear that one additional medical expert for the defense, then they will rest, and then there are 3 rebuttal witnesses for the prosecution who will testify, and that may lead to Monday. The judge has said that the closing arguments could begin Monday or on Tuesday, and then we would be in a verdict watch. While we continue to discuss this case and as it gets closer and closer to an end, let's bring in our guest for this hour. In Minnesota, we have criminal defense attorney Jack Rice with us. Jack, it's great to see you. This is quite a moment for the Lindsay Clancy case. Tomorrow, we could see that end to the defense, and we could also see the end to the prosecution's case. What are your thoughts on where we're at right now?
It's an extraordinary case, Julia. It is. This is unlike many that we have seen. We have seen a lot of cases in which people have been charged with taking their children, now with murdering their kids. And those are all horrific. This is horrific too. But this one is unique because what we have here is not just an argument of a psychosis or an argument of mental illness. We have seen those as well. But what we have is the whole front end of this case, of her life, where it's really establishing just how much she was struggling, and I would even argue just how much the medical community failed her in her efforts to try to retain, to hold on to her sanity. And I think that makes this case unique. It is an outlier.
What's your analysis of how the defense has structured their case, the way they began with more emotional witnesses, and now it seems like we're going to end on a very technical and medical position? What are your thoughts on how that plays to a jury?
We've talked about this. Primacy and recency. The things we remember, the things that stick. The reason you want this emotional is because people will remember things intellectually, but when you hit them in the gut, when you hit them viscerally, those are the things that they remember. And in this case, in particular, what we are seeing is that struggle. The notion of just how horrifying this is, how much she was desperately trying to fix herself, was trying to address these issues with medical professionals, and then having these other pieces of evidence come in, including the statement of regarding Andrea Yates, including some of the other pieces of evidence. All of those wrap around each other and create something very strong indeed.
Yeah, and speaking of how they're ending their case, let's take a look together back at how they began their case. That happened this week. The defense started bringing in witnesses, and they really did start with more personal to Lindsay Clancy type witnesses. People who knew her in her daily life, people who worked with her, including her sister, Allison Ozga, who testified, and her mother. Let's take a listen back to how the defense began, what warning signs they saw, and what relevant things they could share with this jury.
Tell us your name, please, and spell it.
It's Allison Ozga, Allison. Last name is Ozga.
You know Lindsay?
I do.
How do you know her?
Lindsay's my sister.
And can you tell us, are you close to Lindsay? Do you live near each other? Do you socialize? What type of relationship have you had with her?
We're very close. We have not lived in the same state for about 10 years now, but we do communicate, and I do think we're very close.
And do you text with her on a regular basis?
Yes.
And you talk on the phone, do you?
Occasionally.
Directing your attention to the fall of, well, actually heading into like Thanksgiving and Christmas of 2022. Do you remember that time frame?
Yes.
And did you have occasion to see your sister during that period of time?
Yes.
And let's direct our attention to, let's say, Thanksgiving 2022. Had you noticed any change in Lindsay's personality or any observation of how she appeared to you?
I will say on Thanksgiving in particular is when the first time I saw her in person after quite some time. I had known she had not been doing well via text message communication that we had. I think on Thanksgiving, she, her mood did not look good, her energy, she didn't seem very energized. It definitely seemed off from how I've seen her in the past.
And were you aware that that carried through from November into December, around the holiday season, if you had stayed in touch with her?
Yes.
And can you tell us what you observed about her around the holiday season as it related to her, from your observations and your texting and your communications with Lindsay? How did she appear to you at that point?
The beginning of December, it seemed like she very much decompensated. I do remember her saying at one point at the beginning of December, something along the lines of, I'm in a really tough spot. And knowing what she had shared with me previously about how her mental health had been struggling, I had this gut feeling that something was off and that she was really struggling, and I asked her if she was safe.
What did she say?
She said yes at that point.
And you knew her husband, Pat?
Yes.
And you knew the kids?
Yes.
Obviously. Do you recall around Christmas itself, and perhaps a little bit thereafter, that you spoke with her and that she indicated, basically, I'm not doing okay?
Yes.
Can you tell the jury what you observed about her demeanor or her symptomology when you said she was decompensating around that time? What were they symptoms in your mind of?
Based on communication with Lindsay, and I started communicating with Pat directly at that time, she was reporting her mood was worsening, as she described as depression. She was having more suicidal thoughts. Insomnia continued to be an issue. She was really not feeling like herself.
And did you know that during that period of time where she was telling you about the suicidal thoughts and the issue of depression, that she was seeing doctors?
Yes.
And what did she tell you about seeing the doctors, and if she was on any medication, and if so, what effect did they have on her?
So the first thing she said about the doctors was back in October when she said that she saw a doctor for Zoloft and had a very awful reaction to that Zoloft.
Would that be Dr. Tufts?
I don't believe she shared that specific with me.
Share the name? Okay.
No. And then I think throughout our communication over the couple months of October to December, she did share with me that she was going to doctors, she was getting different prescriptions, kind of all the things that they were trying and different treatments they were looking at.
And do you recall when you were talking with her about her symptoms towards the end of December that she had, in your words, decompensated significantly and stated to you that she felt nothing and that she was scared, things of that nature?
Yes.
What else did she tell you, if you recall?
At the end of December, so I think it was more along the same of, that she is really not feeling well. Her mood is down. She's feeling numb. She's feeling hopeless. I believe at the very end of the month, she told me she had had suicidal ideation every day for a month.
Do you recall towards the end of the month around New Year's that she voluntarily admitted herself somewhere?
Yes.
Do you know where she admitted herself?
McLean Hospital.
And while she was at McLean Hospital, ultimately, do you know how she got out of McLean Hospital?
It was my understanding that she was weaning off of some medication that she was on, and then was eventually discharged 5 days later.
Now, did you see her or talk to her after she left McLean Hospital trying to wean herself off of whatever medication it was? Because you don't know what the medication was, right?
I believe it was Seroquel.
Seroquel.
Yep.
Did she tell you anything to the effect that when she got out of the hospital that she felt as though this was a step in the right direction? Did she seem as though she was trying to be positive about her life?
Yes.
And tell us about that, because up until this point, you had observed her decompensating and having these symptoms and suicidal ideation and depression and feeling nothing and scary. When she got out of McLean, what did she appear to you and what did she say to you?
I believe she said she felt that that was a good plan and that she was starting to feel better.
So was your sister, in your opinion, granted she's your sister and you're biased, obviously, but was she a complainer?
No.
And obviously, she didn't share with you in detail her doctors and medicines and things of that nature. Is that fair?
No.
But you were aware of the struggles and the hurt that she was going through.
Yes.
And then through the month of January, did you have occasion to see her, or were you? Because you still live in different states.
Yes. Yes, I did have an occasion to see her in January.
When?
We went to Cora's birthday party.
And that was at the trampoline park?
Yes.
How did she appear at that?
I think she looked like she was going through the motions of putting together a birthday party for her daughter, but she looked tired. She looked like she was still struggling.
So there was a difference in your observation of what you had known your sister to have as a personality?
Yes.
And then, of course, the horrible day, were you aware, or did somebody call you and tell you that the children had been killed?
Yes.
One of them still survived and ultimately passed?
Yes.
And do you recall who told you that?
Yes.
Who was that?
My mother.
And as a result of getting the call from your mother, what did you do?
I jumped in a car, packed a bag, and I sped up to South Shore Hospital, which is where I was told she was.
Did you see her in South Shore Hospital?
No.
Did you know that she was then transferred to another hospital after South Shore?
Yes.
And what hospital was that?
I believe it was Brigham and Women's.
And were you able to visit her in Brigham and Women's?
Yes.
And did it take some time before they would allow you to visit with her?
Yes.
How long, if you know?
I think it was approximately 2 weeks.
Okay. And then you were able to see her pretty much on a regular basis?
Yes.
And where does your mother and father live?
In Connecticut.
And are you close to them?
Yes.
Can you tell the jury, from the time of this incident in January 24th of 2023 up until now, 2026, where have your mother and father been living?
My parents have been spending the majority of their time up here in Massachusetts.
Why?
So that they could visit Lindsay as much as possible.
Almost on a daily basis?
Yes.
Was that in a bed and breakfast or a bed and bath, or was it a hotel, or where were they staying?
They've been living out of hotels.
Thank you, that's all.
Well, we've got to get to a break. When we come back, though, we are going to listen to more of the sister of Lindsay Clancy's testimony, including the cross-examination by the prosecution. Don't go anywhere.
My sister and I are here to support Lindsay. It is not a protest, not a rally, just a silent support to let her know that she's seen, she's heard, which she was not seen or heard by the medical system, by her doctors, by her husband. So we want to let her know that she is seen and heard now.
This was the scene outside of the courthouse early this morning before court started on day 17 of the trial for Lindsay Clancy. Hundreds of people wearing pink showed up for a Stand for Peace for Lindsay Clancy case. Lindsay Clancy rally that was organized. We saw the flyers circulating last week. They're all holding flags representing all the different countries they say people are supporting the defendant in. This is in week 4. Going into week 5 now of this trial, but we're seeing that support and interest in this case increase. Inside of the courthouse, this has been a jam-packed week for the defense, and tomorrow we expect that the defense is going to rest their case after calling one witness today. We're going back to the beginning of their case where they called personal relatives, personal connections of Lindsay Clancy to tell this jury about what they were noticing. And her sister, Allison, talked about noticing a change in the 32-year-old, noticing that she was retreating emotionally and that she was struggling mentally. Now let's listen to how the prosecution handled their cross-examination of this witness.
Come on.
Thank you. Good afternoon. Now, when Lindsay was at McLean Hospital and she was discharged, did she tell you that she asked to be discharged early to go to Cora's birthday party?
I can't recall.
And do you recall speaking to the police on January 25th, just a day after this all happened back in 2023?
Yes.
And do you recall telling them that you saw Lindsay 2 weeks prior to the 24th, roughly around the birthday party time, and that she seemed okay?
Yes.
Do you recall telling the police that you spoke to her in phone calls many times after she was discharged to McLean, and that her tone of voice in those calls seemed better?
I did not speak to her on the phone. Most of our communication was via text.
Okay, so you don't recall saying that to the police, that the tone of Lindsay's voice in our phone conversations was better the last couple weeks since she had been released from the hospital?
I believe when I said that, I meant her tone via her text messages.
And so her tone in her text messages was better?
A bit.
And do you recall telling police that you spoke to Lindsay on Thursday, January 19th, 2023, and she seemed okay?
Yes.
And that was a phone call, correct?
That was text message.
Text message, okay.
Yes.
So when you were saying spoke to the police, you were referring to text messages?
Correct.
And so in that text message, she seemed fine?
She seemed okay.
So she had just been released from McLean Hospital at the beginning of January, and all of your communications after the birthday party were text messages, is that correct?
I think the date's wrong.
I believe so, yes.
And just so we make sure we have the date correct, after she was discharged from McLean in January of 2023, up until January 24th, 2023, all of your communications were via text?
Yes.
Did you visit her at her home that month?
No.
You didn't reach out or call her at all, correct?
I reached out and called, yes. I did not visit her at her home, no.
When you called, did she respond? Did she answer the phone?
I'm sorry, let me backtrack. I can't recall whether I made a phone call. I can recall the majority of our communication between January 1st and January 24th was via text message.
Okay, so there could have been some phone calls.
I cannot recall any phone calls.
You are a licensed social worker, correct?
Correct.
And you're a mandated reporter, correct?
Yes.
And at any point in time between January 1st, 2023 and January 24th, 2023, did you have enough concern about the safety of the kids or the safety of your sister to file a report as a mandated reporter?
No.
Thank you.
Mr. Ray?
All I have, Judge. Thank you.
Okay, thank you. Let me step down.
And joining us now from Minnesota is criminal defense attorney Jack Rice, who's watching along with us. That was a look back at a really important witness here. There were several family members who took the stand in this case for Lindsay Clancy, some in the the prosecution's case in chief, and others in the defense. Jack, what's standing out to you about the sister's testimony that you think is going to help jurors?
When we think about what we're seeing here, is we're seeing her still off. That she doesn't seem completely and utterly incompetent necessarily, but she's off. And I still think what's happening is we go back and we can look at the experts that were presented by the Commonwealth earlier in the case. And one of the things they said was, you can be struggling with psychosis and not be falling down, not be drooling, not be so confused. You can actually somewhat operate normally, and that doesn't mean that you can't be struggling with psychosis. And Reddington was able to get that in through the cross-examination. As a result, while you hear her sister saying she seemed okay, that's actually consistent with that. So if they hadn't been able to get that out of the Commonwealth's witnesses, this might seem more important for the Commonwealth. However, because that came out earlier, this actually makes it, I think, more supportive that Lindsay was continuing to spiral down. And I think that's far more consistent with the theme that Mr. Reddington has been trying to introduce throughout the case.
Certainly, and we are going to hear that theme laid out in those closing arguments that are expected to be on Monday or Tuesday in this trial. One thing that I noticed about Allison's testimony, even early on in the direct, when she mentioned that her sister was clearly decompensating. That is not a word that is used by the average person. So then when you learn that she's a social worker, that she's been in these spaces, perhaps had a lot of interaction with people who are dealing with mental health issues, it's just a reminder of what Lindsay had around her. Her mother-in-law's a nurse. She herself is a nurse. Her friends that were close to her were therapists and people in the medical industry. And I wonder how that impacts this case, how that impacts the prosecution, because there's a question of whether or not this is a prosecution for her privilege. The fact that she had access to so much, that she had the knowledge of how to take the medication and do these things. Do you think that that should be looked at in this case? Whether or not someone who did not have access to the things Lindsay Clancy did would be treated differently by the government?
By the way, that is a brilliant question. It is, because that is one of the pieces of this case that makes it so fascinating to me. During one of the earlier clips, you were showing all of these people standing outside. And they were there in pink, and they were talking about how she was forgotten, how the medical community didn't get it. And yet, what we have here is the medical community is everywhere. Right? We do have her. We do have her sister. We do have her mother. We had multiple psychiatrists who were involved in this case, multiple doctors, multiple people trying to find answers for her. And yet, despite that, what we're finding is those answers did not come, and that they came and they went sideways, and they actually created contamination between this pharmaceutical and that pharmaceutical and the other pharmaceutical. But it highlights your question. Because if we think about where we sit here, all of these doctors were involved, and they still weren't able to come up with a consistent answer. Let's imagine what would have happened if she didn't have access to any of these things. Would we treat her more harshly because she didn't? Or are we treating her more harshly because she did? And that's one of those interesting questions that we have when we think about what it is that somebody faces as a defendant in a case like this. Because, for instance, we treat people the same. We have the same standards for somebody who is a PhD or a doctor or a lawyer who is charged with something, and somebody with serious mental illness, but just on the quote-unquote right side of competency. The standard of behavior is exactly the same, and yet we treat them the same, even with access to all of the availability that comes with wealth, that comes with the capability that the medical community can provide. Even with that, are we looking at Lindsay and saying, you had all of these things and you still couldn't fix it, didn't fix it, weren't willing to fix it. These are all questions that a lot of people are asking. And I think that's one of the reasons those people are outside. It's because they're saying, this isn't just about Lindsay now. This isn't just what one horrible thing happened on the 24th of January of 2023. This is about every woman who has a child and what can happen with postpartum depression, spins into psychosis, even if there's 15 doctors and medical professionals around you.
Yeah, Jack, a lot of people are talking about this case, and they're having discussions just like the one you and I are having right now. Let's take a break, and when we come back, we are going to listen together to the testimony of the mother of Lindsay Clancy. She took the stand early in the defense's case this week, and it was revealing about what was going on with her daughter in the weeks and days leading up to the killing of the 3 grandchildren.
Homeowners.
Welcome back to Court TV Live. Before we get back to our Lindsay Clancy coverage in Massachusetts, we do have a quick update on another trial that grabbed the country's attention out in Texas. Defense attorneys right now in the case for 19-year-old Carmelo Anthony are pushing for a new trial. They are in a hearing right now on that motion for a new trial following his conviction for the fatal stabbing of high school student athlete Austin Metcalf at a McKinney track meet. The new judge took over the case after the original trial judge was recused from the proceedings. Attorneys representing Anthony are arguing that his trial was marred by procedural errors. Now, the defense counsel told the judge that the original proceedings relied on off-the-record agreements and a, quote, shadow docket that limited transparency and public access. We know there were no cameras allowed in this case. It was very difficult to get records, and there was a gag order. They claim that these issues and improper jury instructions deprived Anthony of a fair trial, urging the court today, they are doing that in this hearing to grant a retrial. In the prosecution's opening statements today for that retrial, or for that motions hearing, they claimed that Anthony was spiraling and he was obsessed with fights, guns, and knives, and claims there was a text message from Anthony where he fantasized about stabbing someone. Anthony is currently serving a 35-year prison sentence following that conviction. We will continue to give you updates on what happens in that motions hearing that is still going on. Now, back to the Lindsay Clancy murder trial. Court is going to get underway tomorrow with the defense's final expert witness, and we expect that they are then going to rest their case. And then we will hear from the prosecution's 3 rebuttal witnesses. So we could be in closing arguments as early as Monday morning. Did the defense overall, though, do enough to keep Lindsay Clancy out of prison potentially? We are looking back at some of the most compelling defense witnesses in their case. Let's look now at testimony from the defendant's mother.
All right, good afternoon.
Good afternoon.
Okay, I'm going to remind you, like I remind everybody else, just speak into the microphone if you can keep your voice up, please.
Okay.
Thank you.
Afternoon. Tell us your name and spell your name, please.
My name is Paula Musgrove, Paulamusgrove.
And this is Musgrove. Fair to say that you are Lindsay's mother?
Yes, I am Lindsay's mother.
And your husband is here as well in the blue shirt, correct?
Yes.
You've been here for every day for the trial, is that correct?
Yes.
I just have a few questions for you. Obviously, you tell us about Lindsay when she was a kid. Was she a good kid, a good student, that type of thing?
She was a very good kid and an excellent student. Very excellent student all through school, through high school, college. Yes, excellent.
Ever been in trouble, law enforcement or schools or discipline or anything?
No.
Were you aware of her husband, Pat?
Yes.
And obviously, you knew when they got married, when they were dating and things of that nature, right? Went to the wedding, obviously?
Yes.
Fair to say that you were close to your daughter and Pat?
Yes.
And you knew, obviously, the grandchildren?
Yes.
Tell the jury how you interacted and felt about your grandchildren.
I loved my grandchildren with all my heart. You never know what it's like to love a grandchild until you become a grandmother. And it was the most beautiful thing. I love them with all my heart.
Now, did you have occasion to see how Lindsay reacted and treated her kids as a mother?
Yes.
And granted that you're her mother, so you're obviously biased. Tell the jury what observations you made of Lindsay as a mother through the years after Cora was born, and then Dawson, and then, of course, baby Callan.
Lindsay was a very loving mother. She was dedicated to her children. She was a fun mother. She was always doing things for her kids. She always wanted to be a mother, have many children, and I felt it was the best thing that ever happened to her. And she would do anything for her children. She was just a loving mother.
Now, in 2022, Callan was born. Is that correct?
Yes.
Did you stay in touch with Lindsay and Pat during that period of time, the spring into the summer of 2022?
Yes.
And how often would you see them or talk to them, or what would you do? You go to cookouts, or would you have parties, or how would you socialize?
Myself and my husband would travel from Connecticut to Duxbury at least 2 or 3 times a month, as well as them coming to Connecticut to visit us.
And would you agree that in the summer, for example, of 2022, that Lindsay and Pat were active with the kids and were pretty happy?
Very happy, yes.
Did you observe in the summer of 22 any changes at that point in her personality and the way she was acting with her friends and in society?
In the summer, no.
And they were having a fairly good summer?
Yes.
Did you notice at some point a change in Lindsay's demeanor?
Yes.
Tell the jury when that was.
It was sometime probably around the second week of October.
What happened that you noticed?
I noticed that she had become very anxious. She told me she was anxious about going back to work because Callan was having trouble taking a bottle and she didn't feel right about leaving him.
And as a result of that, did she tell you that she was going to put off going back to work?
Yes, she told me she was applying for an extension.
Now, did you know at that point that she was going through any issues involving depression or anxiety or having any suicidal ideation or anything like that?
At that point, no.
At what point, if any, did you become aware that your daughter was suffering from this symptomology?
In late October.
And how did that come about?
She sent me a text message.
And do you recall when that was?
Yes, that was on October 20th.
Now, Your Honor, the government has introduced into evidence the entire of the phone dumps, if you will, and I think they put it on a disc, and it's probably thousands of pages, but I do have the text thread that deals with that time frame in October. I'd like to offer that so that it's apparent what I'm referring to rather than having to search through thousands of pages of a disc.
No objection.
Okay. They may be admitted.
This was certainly one of the more emotionally raw days inside of the courtroom during the defense case. Let's get to our break, and when we come back, we'll listen to more of Lindsay Clancy's mother talking on direct about her daughter and the things that she noted, and even a surprising conversation that she had with Lindsay.
We thought we were just going in for
Welcome back to Court TV Live. Today was day 17 of testimony in the Lindsay Clancy case playing out in Plymouth, Massachusetts. It is almost the last day of the defense case. We expect her team to rest their case tomorrow and then the rebuttal case for the state, which will be followed by the closing arguments. We're getting very close to a jury having this case. Right now, we're taking a look back at the beginning of the defense case where they called many people close and personal to Lindsay. One of the closest being her mother, Paula Musgrove. Let's go in for more of her direct examination.
Now, the text message that you're referring to, would that be on October 20th of 2022?
Yes.
And do you have that on your phone right now?
I do.
Can you just pull that up for us?
I can. Just give me a moment. Okay, I have it.
Kelsey, do you have a copy maybe that she could look at?
Oh, I have a copy.
Yeah, that might be easier for the witness.
So I'm going to approach you with this board and ask if this is a copy of the text that you're referring to.
Yes, it is.
Would you read that for the jury?
Mom, will you please come up and stay with me for a bit? I'm really sick. Something is wrong. I had horrible insomnia all night, and I just don't know how I'm going to get through the day. I started taking the medicine my doctor prescribed for anxiety, and I think it's made things worse. It's just really scary, and I don't want to be alone.
You want to write off this?
Objection. It's already in evidence.
What do we mark it for identification? Is that text within the?
I'd rather have it in the board.
Well, I know you would, but we already have the.
They want a little painting. Can I just have the board like?
No, we're going to mark that for identification. The text that is been referred and read to is within Exhibit 276, which was just off.
I'm sorry, which is what?
I think it was within Exhibit 276, which was within that thread that you just offered.
Okay, so I will then, that would be 276, so that will be over here. As a result of receiving that text, did you then come up to...
Hold on a second.
Exhibit W for identification.
Yeah, okay.
Oh, thank you.
All right, thank you.
So as a result of that, did you come up to Duxbury?
Yes, same day.
And tell us about that. What happened that day at the end of October?
Lindsay had been, I believe she went to the emergency room that day, and she had come home. She was feeling a bit better. She told me that she couldn't sleep. She was very anxious, and she was afraid.
And how long did you stay with her?
At that point?
Yes.
I believe at that point I stayed for about a week.
And was your husband with you?
He came later. He didn't come directly with me then because he was still working, so he came later.
I never asked, what did you do for work?
I worked for Weight Watchers.
And you're retired?
Yes.
How about your husband? Is he working now?
He recently retired.
And what was the nature of his work?
He was in photography.
What kind of photography?
School picture photography.
For yearbooks and things like that?
Yeah, and school pictures, and you had your kids' pictures taken.
And he just recently retired?
Yes.
Is it fair to say that during the month of October into November, into the holidays in December, that you and your husband would stay with Lindsay and the kids?
Yes. I stayed more than my husband because he needed to go back home to work.
Sure. While you were staying with Lindsay, can you tell us your opinion as to her condition? Was it decompensating? Was she getting better as time went on through November and December into the holidays?
Through November into December, it was not getting better into the holidays.
And you knew she was on medication at that point?
Yes.
You knew she was seeing doctors at that point?
Yes.
So tell us, is there an incident that came to your mind that you recall that occurred on one evening that indicated to you how seriously she was suffering?
There were many. one particular evening that was disturbing to me was that, I mean, she was afraid to be alone, and she actually asked if she could sleep with me.
When was that?
That was late November, early December.
And did she indeed sleep with you on that occasion?
She did.
Continuing on through the holidays, did you guys get together for the holidays, Christmas or Thanksgiving, if you recall?
Yes, I was down there probably most of December through Christmas Eve, and then I left on Christmas Eve to come home to see my other daughter and her family, and then Lindsay actually came to my house later the day on Christmas Day.
Was she with Pat?
Yes.
Okay, and the kids?
Yes.
During that period of time, did you make further observation as time went into January? Oh, back it up. At some point, she voluntarily went into McLean Hospital?
Yes.
You knew that?
Yes.
How did you know that?
I was there.
What do you mean you were there?
I was at Lindsay's house staying with them.
You take care of the kids?
Yes.
And it's fair to say that Pat's parents, mom and dad, also stepped up, taking care of the kids, helping out during this period of time?
They were there, I guess, when we weren't there. I didn't really see them, but...
Right, because you guys would be different time frames.
Right.
But you all were pulling together as a family, is that correct? January, leading up to January 24th, do you recall, and can you tell the jurors what, if any, observations you made of Lindsay and her condition?
Lindsay had lost a lot of weight. She had become, during this whole time, paranoid about different things that really she shouldn't have, really weren't logical to become paranoid about. She would mention that this wasn't her mind. She would say to me, this isn't me. I've never been like this before. And I would agree because she wasn't. She was attempting to go through the motions of her day, take care of the kids as best she could. She didn't want to drive. So at times when Pat didn't go pick the kids up at school, I would drive Lindsay to pick the kids up at school because she was afraid to drive.
Did she express to you concern that in this time frame that people at the school, teachers and other people would be able to know what she was thinking and would think that she wasn't a good mother because she was sick?
Yes, she said the school knows something's going on because I'm not driving my car. They see that I'm not driving my car to pick the kids up.
Do you recall the end of January that she made a statement to you about the medication, in her opinion, what it was doing to her mind?
Yes.
What did she say?
She said that she couldn't remember anything. The medication was pretty much just destroying her mind, and it wasn't her. She said, this isn't me. I just want to feel better and enjoy my kids again.
Now,
let's bring back in former prosecutor and criminal defense attorney Jack Rice with us. Jack, she was a very compelling witness in terms of what she could share about Lindsay, and you just felt the heartbreak of losing her grandchildren through her on the stand. We don't hear from Lindsay, but hearing from her mother, I think, was very helpful in bringing out that emotion in this trial. What did you think? What did you write down about her testimony?
Two things. I almost got up when she said that about her grandkids. I almost had to walk away from it for that reason, because you can feel the pain of it. And it felt so authentic. When you listen to her, you believe everything that she says. The other aspect of what she does as a witness is she is as close to Lindsay's voice as we seem to get, at least what I've seen so far. Because it's not just what Lindsay says. It's how Lindsay feels when she says it. And it feels like if anybody understands this, Mom does. Mom knows what this feels like, and when she's saying, it's not me, this is not these are not my thoughts, this is what's going on, I'm losing that. And then when she said one thing, I don't know why this grabbed me, when she said, Mom, can I sleep with you? Can I get in bed with you? And I thought to myself, How far gone are you when you have to get to that place where you can just wrap up like a child in your mom's arms? And I thought to myself, that grabbed me. That grabbed me in a way that other things didn't. And what it really highlights that this is the kind of witness that the defense needs. We can talk about experts all day long who can talk about mental health and illness and psychosis from 10,000 feet. But when you talk to a mom about what it feels like to have their daughter say, I'm lost, I can't find myself, that is the kind of evidence that will stick with the jury and that will haunt them, which is exactly what it should be doing. That's what it's for.
That's what the defense wants. That was a moment, the one that you mentioned about her mother saying that Lindsay wanted to sleep in the bed with me. It resonated with viewers. A lot of people talked about that. When you get to that point, I think it counteracts what the prosecution wants to show about Lindsay Clancy, that she was this controlling, over-organized, just obsessed with things being a certain way. But you see there the slipping away from that. Maybe the organization is to hold everything together, but again, we go back to that prosecution because of the options, perhaps. She could have let her kids stay with her mother. She could have let her kids stay with her mother-in-law. I wonder if prosecutors are going to highlight that a lot in their closing.
Well, yeah, they're going to have to, because I think a lot of their theories are falling flat and the witnesses are simply cutting against those. So, yes.
All right, Jack Rice, stand by. We've got to get to our break. When we come back, we're going to look at the cross-examination, what the prosecutor wanted to bring out of Lindsay Clancy's mother's testimony. This was early on in the case where we are about to see tomorrow the defense rests their case. Don't go anywhere. You're watching Court TV, your front row seat to justice. its case. And this, as interest in the case appears to be steadily growing, both inside and outside of the courthouse. This is what the gallery looked like today, a completely crowded courtroom for day 17. And outside of the courthouse, we saw crowds, hundreds of people gathering, wearing pink, supporting Lindsay Clancy. Her defense has not officially rested its case, but we hear that they are close because they only have one witness who's going to testify tomorrow. There are 3 rebuttal witnesses who are scheduled by the prosecution to show up tomorrow, and if their testimony only lasts for tomorrow, that means on Monday we could be in verdict watch. We could hear those closing arguments, and then this jury would be deliberating this case. While we are waiting for things to start up again tomorrow in that case, we are looking back at some of the most compelling testimony that we've heard so far, especially in the defense case. They started earlier this week, and now we're going to listen to the cross-examination of Paula Musgrove. She is the mother of Lindsay Clancy. She told this jury about her daughter's struggles, where she didn't trust her own mind at the time. This in a case where the defense says postpartum psychosis is what led to the deaths of these 3 children at their mother's hand. Let's go in and listen to the Commonwealth of Massachusetts ask the questions of this mother.
Good afternoon.
Afternoon.
Now, you testified in direct examination about the statements that Lindsay made in December about having thoughts about harming the children. When in December was that?
I don't exactly remember. I would say early to mid December, probably maybe earlier rather than mid-December, but I don't exactly remember when.
Okay. And when she made the statement that she had thoughts of harming the children, did either you or Patrick ask her what she meant by that?
I believe I remember Pat asking her if she felt like she couldn't be alone with the children, and she said no.
And after she made those statements, did you have any thoughts about committing her?
No.
Did you have any thoughts about having her come stay with you in Connecticut away from the children?
No.
Were you concerned for the children's safety at that point in time?
No, because I was there.
Okay. And you were asked about some text messages in October, and those are now an exhibit, I believe. Exhibit 276. And so you talked about the text on the 20th when she asked you to come and she was having a hard time, right?
Yes.
A day before, on October 19th, she had sent you a different text message stating, "Hi, Mom, would you ever consider coming to stay with us for a couple days at a time to help with childcare so I can work?" And talking to a therapist and doing a lot of thinking, I actually think going to work will help me, but it's really hard with nurses' hours to get childcare that we need. I'm thinking if you could come like Sunday to mid-Tuesday, it'd be really helpful, just a thought. Do you remember that text the day before?
Yes.
And did you agree in a text message that you said I can come and help out?
Yes.
Okay. And then after that next day is when she said she was having trouble and wanted you there then, and you went that day, correct? But you said you were there for about a week, but there's a text on October 20th that's not included in this exhibit, where on October 24th at 2:36 p.m., you send a text to her saying, "How are things today?" And she responds, "Good." You remember that?
Yes.
So were you already home at that point when you were asking her how she was doing on the 24th?
I must have been home at that point. I honestly don't remember. I was back and forth so many times. So the time frames are really jumbled in my head as far as how long I stayed any particular time.
And so you would go and help out when they asked you to, and then you would go home when things were calmed down a little bit. Is that right?
Not exactly right.
No? And she did say on the 24th that she was doing good that day, correct?
I don't recall, but if that's what the text says, then.
Here you go, you can look at it.
Yeah.
she told you at that point on the 24th she was doing good, right?
Correct.
You could have this page marked as the next exhibit.
Any objection? No. That may be marked.
277.
Now, you talked about a time when you went to her home and you actually ended up sleeping with her because she didn't want to be alone. Was that October 20th visit?
No.
When was that?
That was, I can't exactly remember when. I'm going to say probably sometime in November, the latter part of November, maybe the early part of December.
Did she tell you why she was afraid to be alone?
She just said she was afraid to be alone. And one reason, I believe, she said she didn't know if she was going to be able to sleep, but mainly she was afraid to be alone.
And at that point in time, did you consider having her committed to a psychiatric facility?
No.
And did you feel the need to call 911 that day or get her immediate assistance?
No.
You mentioned that in January you saw her and she lost weight. She seemed paranoid about things, seemed to be going through the motions of each day. How often did you see her in January of 2023?
In January, I can't exactly remember how many times I saw her. We were, again, back and forth.
So we have Exhibit 238, which have all of your text messages with Lindsay in January of 2023. And I just want to go through some of them with you. So on page 17 of the exhibit, this is on January 4th, 2023, so the day before she was discharged from McLean, and she sent you a text stating, "Think I'm coming home tomorrow evening," exclamation point. "I talked to the doctor and I made up a follow-up appointment with my other psychiatrist besides Rebecca for Friday morning, so she said she'd be okay with me leaving Thursday around 5. Do you remember getting those messages?
Yep.
And were you staying at the home helping out with the kids at that point?
Yes.
And did you go to Cora's birthday party on the 7th?
I did not. It was a children's party. I stayed home with Callan.
Okay. And do you recall when you went home?
I don't recall.
Looking at page 28, and there's a text from Lindsay on January 7th, 2023 at 7:02 p.m. to you where it says, "Make it home okay," and you said, "Yep." Does that make sense that you would have gone home on the 7th after the birthday party?
Yes, if that's what the text says, yes.
And then on page 29, we have text messages between yourself and Lindsay on January 8th, where you ask how things are going today, and she says, "Good, going to the Science Museum." You say, "Great, that will be fun. Sleep good last night." And she said, "I actually did, with less Ativan, so that was good." Do you remember that?
I don't recall the exact text messages.
Do you recall her texting you about going to the Science Museum?
No, I don't recall that.
Do you think looking at them might help?
Sure.
I'm going to show you page 29 and then page 30. Does that refresh your memory?
That's what the text says, yes. And then on
Page 34, you ask how the museum was today, and Lindsay sent you some photographs and said it was fun, the kids really liked it. Do you remember that?
I don't really recall the Museum of Science experience or text, but if they're there in the text messages, then they were sent, yes.
Okay. Then on page 39, this is January 10th. You say at 9:48 a.m., "Good morning, how are you doing today?" And Lindsay responded, "Good, at the gym with the kids." You said, "Nice, still sleeping good?" And she responded, "Pretty good, yeah, not perfect, but enough." And you said, "Are you feeling any better during the day?" And she said, "So far, a little bit." They said a week off the Seroquel should make more of a difference, so a couple more days till that, but I do think it's helping being off. And you responded, "Okay, a little at a time." Do you remember that conversation?
So I don't recall the exact conversation. I think I probably texted back and forth to Lindsay almost daily during that time, so I don't remember the specific text messages, but I would say if they're there, then that's what we sent back to each other.
Okay. And then there were further text messages that day. Where you say, "How was your day?" later on in the day, and she said it was good, played with the kids a lot, were able to go outside, Kingsbury Club and gymnastics, kept them busy, and me too. So do you remember her talking to you during that time about going to gymnastics and going to the Kingsbury Club and things like that with the children?
I don't remember the specific text, but I do remember her doing things with the children, yes.
Then on January 11th, the following day, you sent a text, excuse me, "How are you feeling today?" And she responded with a photo of Callan drinking out of a Mary Lou's cup, saying, "We have another Mary Lou's fan." And you said, "Decaf, looks like he's enjoying it." And then later on, you asked again, "How are you doing today?" And she said, "Hi, Mom, doing all right. Nothing new, really, just taking it day by day." You said, "Still feeling a little better." And she said, "A little bit." You said, "Sleeping okay." She said, "Not great last night because Cora was up with a bellyache." Do you remember that?
So again, we texted so many times daily, twice daily, maybe 3 times daily, so I can't say that I remember the specific text. I do remember the picture of Callan with the Mary Lou cup because that stands out in my mind. But the specific text going back and forth, we just did it so often that I can't say I remember the specific text you're reading back to me. Okay. But again, if they were there, then we sent them.
Right. And do you remember Lindsay talking to you about Cora having stomach issues during the month of January?
Yes.
Some belly aches off and on?
Yes.
Prosecution spending a lot of time with those text messages in the weeks leading up to these killings. Let's bring back in former prosecutor and criminal defense attorney Jack Rice. Jack, when you're hearing this mother talk about the check-ins, I'm wondering what you're thinking as someone who has represented so many clients and many that have touched the mental health spectrum, the wide range of those different cases where you have family members and there's often some scrutiny of what family members do or do not do in these cases, which they should have done, the hindsight being 2020. What have you learned? What's your conclusion of when parents or loved ones should be stepping in more? Because here it seems like they were monitoring things. They were checking in with her. They were asking her, do you feel safe with the kids? And if she said yes, then they let that be the answer.
You know, I think about this, Julia, for decades now, and I think about this, you know, as a father too, right? When we all think about these issues where you want the people around you okay, and sometimes what they ignore is the last 25 or 30 or 40 years of effort, and that you're trying to be optimistic where they're not totally off the rails, and so therefore that's pretty good. You know, when you keep asking this question, did you think about having them committed? And my thought is, we've thought about that for many years. Or now, are you asking me now as I think about my 3 grandkids who are in the ground? I mean, there's the piece of this that is so frustrating to see, because what I'm watching now is somebody who was struggling, clearly Lindsay Clancy, but what you're getting from the prosecutor is, but she was okay on this day, and she was okay on this day, and she was okay, or reasonably okay on this day. So now what you're doing is you're starting to cherry pick the days that are good days versus the days that are horrible days. And then you wonder why it is that the family isn't doing more. And I come back and I'm thinking, well, let's think about what the experts were saying. These are just people who are doing their best. You can see this mother, loves her daughter, loves her grandkids, is trying, but she's no expert. She doesn't understand just how bad this can be, just how quickly this can go off the rails. And I find it a little repugnant myself to somehow, at least it feels like there's a little bit of blame that you're placing on this mother. And that bothers me very much.
Oh, okay.
And I think it bothers this jury because this is pain personified. And to say, it's your fault. You could have done more, but you didn't. And you're like, what am I supposed to do? And I think that's a really important factor, a human factor, that this jury is starting to weigh against the Commonwealth.
Yeah, we don't know what's in the minds of these jurors, but I will say that our representative who's there inside the courtroom noticed them seeming to be taken aback when the prosecution went after the mother-in-law about whether or not she knew that murder is a mortal sin. So there are reactions from these jurors that are happening that we pick up on however we can. Jack, we got to get to a break. We're going to keep talking about this case, though. When we come back, we are going to take you to how the defense ended their case today. Don't go anywhere.